Hi guys, let me know you can hear me. Hope everybody's doing well. Yeah, I put Tasha in the back, in the corner. Number one, only because she was getting sleepy and she was going to be way over there anyway. So I figured, well, let her hang out. Tasha, what's going on? Anyway, let me see who's all in the house. Yeah, and Michelle M says we can hear you. Awesome. All right. So how's everybody's week? Is it good? I had my I know you guys. Seems like every one of my clients has this. This is my first time. The old colonoscopy. This one has a combination colonoscopy EGD because of my little GI, whatever issue that is. Anyway, so that's kind of interesting. It wasn't a big deal, really. The nap was good. Gosh, that's awesome, isn't it? Imagine if we'd all sleep like that at night. That'd be amazing. Okay. I see George is in the house. George was the first person in the house. Hi, George, from Punta Gorda, Florida. Good to see you. I appreciate you showing up. Kevin Johnson in the house. I love seeing people who have prevailed and still like to visit us. So that's awesome. Dimple's in the house. Hello from Ohio, where useless nut is our state logo. Ooh. A useless nut. Okay. Some nuts are good, right? Protein, maybe fiber, fat. All right. Dolphins in the house. RD from California. Michelle Emma's in the house. Good morning to you too, Michelle. Thank you for letting me know you can hear me. Z Shine. Z Shining? Z Shine. Happy Wednesday to you too. Miami Heat's in the house. Hello from Florida. Hi, Miami Heat. Is that from an old show? Danny's in the house. Look at you on time, Danny. Deanna's in the house. Hi, Deanna. Gregory Petty's in the house. Nicole Cacola. All right, I see you got a possible question there, Nicole. I will definitely get to it. So thank you for coming. I appreciate it. Greg Petty. Yep, we got some questions. Okay. All right, I'm scrolling back up. Anyway, I appreciate it. And I hope everyone's having a good week. Let's see. I think Greg Petty. I think you have the first question, Gregory. Gregory says, it's been almost 2 weeks into the month of May, and I still have not received my CDR scheduled for this month since I am on a 3-year review, and I hope I won't get it at all this year or next. Yeah, well, the diary is just an estimated time of when you, at least the time it was applied, and they kept it, that you should be reviewed again. That doesn't mean, and that's usually based on the, well, at the time, I think they do consider your age and everything, but I think mostly it's the conditions which disable you. But I don't know that many of them go off exactly on time. I don't know. No one ever shares with me all those experiences, so I don't have a good view or perception of whether that may be. But and I know it's annoying because you would like to just get it over with. Maybe you prepared for it. Maybe you know what I mean, and you want to kind of relax after. So I could see that would be a little annoying and a little frustrating. Dimple's just peachy. Good to hear it. And there's a picture of a peach. Cute little things. Okay, so Nicole says, my husband has his SSDI judge hearing. So that would be his ALJ, administrative law judge, in 1 hour. Please say a short prayer for him. Oh, yeah. I'm not good at out loud prayers since I'm just kind of I haven't been praying out loud for very long, but I would definitely ask God to look at him with grace and mercy and all that, and support him in what he's trying to accomplish here for him and his family. Greg, and everybody else, if you got something going on, please feel free to share it to Nicole. Most people have been there or they're about to be there, so you guys all kind of know what it feels like, right? Gregory says, I was told to check my online SSA accounts and someone on Reddit got a flagged online form link. Awesome. That was a question we've had in the last few weeks, Gregory, I think. Do they let you know through your SSA online account if you've opted to gain access? And I know some people are like, I don't want to do it. They're going to make me answer questions or biometric me to let me get into it. And that's really just to prevent fraud, but if you do, you'll know things like this, right? So he's saying that someone on Reddit got a flagged online form link on there months before they finally received a physical letter. So I checked my SSA online accounts and nothing. Since the feds started processing CDRs just recently this past March, they must be really behind. No, it's, I'll explain again. I know I've explained this before, but I'll explain it again in a second. He goes on to say, I've read on Reddit that some people have gone months to a year and a half without receiving. Yeah, that's actually not new. They only moved it over to the feds like what, a month or two ago. And I'm not even sure if it's moved over fully. I haven't read anything about it. But what happened was in 2024, they halted all CDRs, Gregory, for like 6 months because they were so behind on initials and recons, and people were sitting the point where it gotten where people were on initial or recon for well over a year, and they were trying to, get that assisted. They'd already done a hiring freeze back then in 22 or 23 or something like that. So in 2024, they couldn't per se hire more people to do more initials and recons. So they quote unquote froze the CDRs, and they had all the people working on initials and recons. They opened the spigot again. I want to say end of 2024. I think could have been very beginning of 2025. So it was like a 6-month hiatus, and so that's 6 months of CDRs that none were done. It wasn't like they were even done. Like this, no new ones were coming on board. So I can imagine that's going to take quite a time to get through, unless you go and hire a bunch of people for a temporary job. But I don't know that they would be able to learn it fast enough. It's kind of I think you should be really well tuned to the law if you're going to be doing this kind of work. So getting someone on for the short term, if they're not already really experienced in it, I think you're going to spend, I don't even know how long it must take to really learn the job well and do it right, without 10 million steps of oversight. So whether that is why it's still slow, but you just said you're supposed to get it now, so I don't know that you're really behind, and for them being like, it's been years where they would be like, and it depends on the case. I think the people that got the earliest, I don't know what your diary date was. Hi, Tosh. I don't know what your diary date was, but it seems that the people with the shorter diaries, because they're more expected to improve based on the kind of impairments they have that are historically, the kind that improve enough to go back to work. I think those are the ones they jump on first. So they're going to prioritize, and the ones that are, 5 to 7 year, and a person who's 60, I think those are going to be the last ones to be considered and probably will never happen. They might do a short form or sometimes people just get a letter that says, we decided that, basically don't need a CDR, and then we think you're still disabled. So you got the pass. Now that doesn't mean you shouldn't necessarily find out when your next CDR is going to be then, since basically this one's over with a blink, right? But so that might be you. I don't know. Again, if you have a long CDR, I don't know what age you are, Gregory. You might have told me in a previous week, but I don't recall. So my apologies there. But maybe that's what it's about. You know what I mean? But I wouldn't think that if you're due in May and you haven't gotten it in May, that it's really a problem. It could just be that you're getting bypassed, which would be nice. But it would be nice to know, right? I've gone months to a year and a half without receiving their schedules. I thought you said that you were just supposed to have it in May, Gregory. And now I'm confused. Oh, yeah, you said it's 2 weeks in May. Now I'm supposed to have it in May. Well, yeah. So I don't know what you're saying about a year and a half and 2 years now. That's probably just me, though. I'm probably just misunderstanding something. Yeah, so, yeah, I don't think it's a matter of being more behind at all. There's just the reason why they had to do all this change up is because the states just didn't have sufficient workers to do it. So, and initials and recons should be the priority. Yes, getting people off who are completely able to work, all good. Yes, I think that's important too. But I don't think it should be at the expense. The process has to be improved, and the first thing they should do is never tamp down on the initial and recons, because those are the disabled people who need to get started, right? Need to get the ball rolling, versus rushing the people off, even the ones that should be off. And there are some. Dimple says Buckeyes are poisonous. Are those nuts? We're the Buckeye State. Oh, well, that just means that in those sports and in anything, you guys are powerful, and you'll take out your enemy, right? Your nemesis. The Buckeye State. There must be something. Oh, maybe it's yeah, a poisonous nut. I'm sure there's use for it. And remember, some things are poisonous if taken, say, in the blood vein, but if you take it orally, it's something totally different. Isn't that true of snake bites, or some of them? Or is that just TV from when I was a kid telling me that? That's possible. Never researched it, just throwing it out there. And Dimple says, of course, unless you're talking about the one made with peanut butter and covered in chocolate. All right, guys, if you have questions, pop them up, because I will be jumping down. Yeah, those are pretty yummy. Dimple says, I'm post-up and on pain meds, so forgive me, but I do have a good excuse. What are you, a little loopy? Nicole says, thank you so much. It was perfect. Oh, wow, that's cool. Thank you, Nicole. Yeah, I'm a little clumsy with that stuff. It's not my forte. I do try, though. Every day, actually. Okay, Sybil Chick says, hi, Joy. Never caught a live before. You didn't? Weren't you here last week? Love your videos. Love Walter, too. Walter. I thought you were here last week. Where did I see you? Else? I know you were here. Or we interacted. Maybe you did a post on one of the videos. Else says, what if I made a mistake on my SSD application, rate transfer of funds? I had forgot that I transferred dollars to my parents to pay them back for loans. I answered no, but the answer should be yes. SSDI application, where does it? I'm just trying to think. Where does it ask you about transferring funds? It's none of their business for SSDI. If you're SSI, then yeah, if you're like squirreling money to someone else and then with this hand asking for the taxpayers to support you with SSI welfare, obviously that's going to be a problem. And if you did make a mistake, you just tell them now and just say, because there's a time frame too. Like they want to know, this is for SSI only, guys, because it's needs-based, it's welfare, it's not the stuff you earned and paid for, and it's not insurance proceeds of insurance that you bought. So I'm not sure where you're saying on an SSDI application that question would be. So I'm wondering if you meant SSI, I'll say. Civil Chick says, I'll say, you mean SSD. No, Civil, let me clarify. SSD and SSDI, guys, are the exact same thing. Social Security, disability, insurance, Social Security, disability, and they left off the insurance. That is the same. Those two acronyms represent Social Security, disability, insurance benefits. SSI, when there's no D in it, that's the welfare program. You still have to be disabled, and it stands for Supplemental Security Income. There's no Social Security in it at all, and it's about income, not insurance. So it's because they're giving you income. It's not that you're getting the proceeds of insurance you bought. Okay. Richard Unknown is in the house. Hi, Richard. Nice to meet you. I don't think we met. Your dog is really cute. Is he yours? How do you know when it's time? How do you know when it's time refile your SSDI claim or take it to federal district court? Well, here's the beauty of it. If you have, let me just finish this question before I jump in in case I screw up. My judge basically said in a PC kind of way, yeah, mental health is subjective. Doctors just write down what you say. Well, he has a point. There's no objective marker. So a lot of what they're relying on is what you say. That's a fact. Doesn't mean people don't want on mental health, but to prove that you are so mentally off that you can't work a job, even a simple third grader job because of it, you pretty much almost have to be like frequently admitted to a psychiatric ward because, you know, in the eyes of the SSA, what your job is to prove if you're not frequently getting psychiatrically admitted for weeks on time at a time is to prove that nonetheless, I can't work a job. And maybe the only reason I'm not again in a psych ward for now for a few years, I've been doing better in that regard, is because I now have this very sheltered, structured environment. My family cares for me. They take care of me. I don't go in public, whatever your, let's say it was some sort of fear of public, you know, social phobia, severe, like where you're going to puke if you go out in public. I mean, whatever it is. If it's garden variety anxiety and depression, it's never going to pass. Never going to pass. If that's what you're relying on as being your sole disabling thing. But the question about how do you know when it's time to refile your SSDI claim or take it to federal district court? First question you got to ask is my DLI, date last insured, after that judge's denial? So look at the judge's decision, and in the front of it, on the upper right, it's going to say what date, he issued that decision. That's the date of the decision, a very important date. Then within it, if you don't already know it, and if you're not working at all, like even part-time under SGA, the date that he has in his decision with regard to what date you're insured till, your DLI is in there. The record reflects that he is insured through so-and-so date. If that date, Richard, is before his decision date, you cannot file for SSDI again because you're not insured for it. You stopped paying the premium some time ago and the term ran out. Sometimes you stopped working some time ago, but the term hasn't run out because you had enough to buy, say, 5 years and you're only on year 3 or something. But that's something you need to know. Another really important thing to know is if you can file for SSDI because those dates work out, you can do that now. Now that if the appeals council declined to review your case and now your only option is federal district court, you can do both. And you have a short window, 60 days to file 60 days to file the federal district court. You have far more time with SSDI. However, if it will make a difference when your protective filing is for the SSDI, generally, and I can't say whether there's exceptions or not. I don't think so, but don't hold me to it. I'm not looking it up right now. If you file your new claim within the 60 days, is that for SSI or SSDI? There's a 60 day. There is a time frame. Maybe I'll go find that one done. Let me just take a note. Okay. Because I'm thinking it could be 60 days for SSI. No. I want to say 60 days, but then I thought I read something about 6 months. And this is separately from the regular protective filing we talked about. If you file your new claim right after you get your appeals counsel decline, aka denial, in that window of time that's going to be in the rules, they will use the date you filed for your AC appeal as your protective filing date on your new claim. Because remember, that's going to be after your ALJ denied, a little 60-day window there. And then if you filed your AC appeal in time within the 60 days of the ALJ denial, and then you might have gone a year before you got your denial by the appeals council. That's kind of unfair to say, well, the person now loses all that time because we were so slow. They let you have that protective filing date back to when you applied in your AC. And if I was filing, I'd probably put that in my cover letter, or someplace. If you're doing it online, you're pro se and you don't do cover letters, you're not sending in a 1696. Maybe put it in your remarks, like I appealed for AC on so and so date. It was declined, 35 days ago, and it is my understanding, and if you can quote the rule, that's great, that I have a protective filing date on this new claim back to the date I filed for the AC appeal, which could be a year ago, could be 18 months ago. Sometimes they're really slow. So that's something you definitely want to do, and you do not want to breach your window. Don't delay filing new, but you can totally file new when you have federal district court going on. Before you file it, maybe you'll never file it, maybe you will. I mean, FTC, federal district court, you could do them both at the same time, is my point. They can both be running simultaneously because the federal district court case is only handling the old case, and that ended with the judge's date. And then your new one is going to be everything, probably the day after the judge's decision is usually what people put as their technical alleged onset date. And going forward, I mean, if you don't put it and you put down your original date, that's fine too. They're just going to correct it because there's an ALJ denial and it is now the rule of your case, unless the federal district court turns it over. So I hope that helps explain it. You can do both, and I would absolutely do both. I mean, if you have someone that does FDC work in your location, and they're not that common. Some people that's all they do. Then great. And if they'll look at your case and they will look to see if it's in their mind viable to win on. Because remember, they're working for free until they win. So they will reject it and not be willing to work for you if they don't see an appealable issue. And it's not a judgment as to whether they think you're disabled or not. It's whether because remember, the whole question is, did the judge not follow the rules before he rendered his decision? Did he follow every step in the way it needs to be followed? And if not, then it's usually remanded by the federal district court, just as it would be by the appeals council, back to him to redo everything and give you another hearing where this time, before he renders the decision, he has to follow all those steps. Doesn't mean he has to award you, but he just has to follow all the steps, and it has to be clear from his decision that he did so. And you can... I mean, I have known people who have filed pro se because they didn't have an FTC lawyer. You could do that too. You got to learn how to do it. Obviously, it's not. It's probably not intuitive. I mean, I'd have to do a ton of research to do it. I don't do them. I focus on what I focus on. But if you can get someone who does it, it means that they think you have a decent chance of prevailing. So that might be something to consider. Gregory says he's on a 3-year diary and just turned 38 years old 4 months ago. Okay, that was probably in response to my question about he's feeling that, gosh, they said I'd have it in 3 years, and that's this month, and I haven't heard anything. And I heard on Reddit that they put it up in your SSA portal to alert you that it's going to be coming down the pike. Yeah, yours just might be, if they're going to issue that. I don't know how reliable that is, but, I assume it's true. Yeah, maybe they're just like, you're not the top priority in those 3-year people. All the ones that should be in May, maybe there's some that are way more priority because they're way more likely than you in the 3-year, people to have recovered. So I think it's a matter of trying to be properly prioritizing rather than just willy-nilly helter-skelter. But you are on the shorter rope, so you are expected to recover. It doesn't mean, and I don't think that means, well, there's probably a 55% chance he's going to recover, therefore we expect it. It could, whatever, I don't know what their gauge is. Let's say there's a 20% chance you recover. Is that considered expected to recover? That's a pretty good chance. Because if they didn't do them at 3 years then, because there's only a 20% chance, that means, do you know how many people would be, that 20% of the people actually recovered enough to go back to work and still would be collecting out of the funds when they were improved enough to work? So, you know, there is no way to quantify it. I just think that they're getting to the ones that are the top priority first. This is my guess. And it will be done because you're only 38. You got a lot of years of being pretty young. And, you know, it'll happen. I would be very surprised if it didn't happen. Unless, of course, something turns in the negative with your impairments, and now you're in a new category. And I hope that doesn't happen to you, because that would be horrible. Gregory was disabled since 2020. So this is your second CDR, would you say? Sunshine's in the house. Will having a master's degree hurt me for my disability application? I'm 60 years old. How old is your master's degree? Is it last year? In the last few? Or is it a little antiquated? Because that's, you know, Sunshine, that's old girls. Like, how much will my law degree hurt me? It probably wouldn't hurt me as much as the fact that I've been practicing it in the last 5 years. So my skills. So if you're doing, let me explain this. The schooling is, the question is, will that schooling provide for direct entry into a skilled job without having to learn everything, right? So old degrees don't really hurt you. What matters, what it comes, but new ones may, because you just learned how to be a nurse. So either you have all the up to date skills. Let's say what you did was you got a nursing degree, master's in nursing 20 years ago. You worked for the first 5, then you stopped working. Maybe you had kids or whatever, and then you got disabled. That master's degree is not worth much. And it's not going to speak to transferring skills, of course, because anything that you learned then certainly doesn't hold water now. Science is always changing, right? And we know the medical profession, oh, something's true, something's not true. You know, like, it's always changing. So the old degree won't hurt you. However, and neither will, if you haven't been working in that job, then you don't even have the nursing skills, the hands-on skills that are transferable if they haven't been done in the last 5 years. So that's what it depends on. So if you have no recent education, then they look at your 5 years of work and say, well, are these jobs, do they contain transferable skills? And if so, that's the ones you have to fight against. Let me know if that's clear, guys. I know a lot of people worry about being highly educated. The higher education doesn't matter if you haven't been working in gazillion years. Like, let's say you got my aunt, for instance, I think she got a law degree or something. I think this is like, I mean, decades and decades and decades and decades ago. I think she, for whatever reason, decided not to sit for the bar. This is in Sweden. And I never really learned why. Maybe she was afraid of, maybe it was like a fear of failing. I don't know. Because it seems like after all that work, right? But no one ever really told me, so I don't know. Her law degree wouldn't have, if she went on disability as a younger person, which I don't know if she ever did. I don't even know if they have it over there, because it's Sweden and, you know, it might be totally different. But her law degree was never used to be a lawyer. In fact, she was a horse person and did stuff with horses and did things completely outside of that. So, and I don't really know what even her job was, you know. But so that law degree would have not been a speck in the eye if this was taking place here. Whatever work she did, if she was a cashier, it would be any of those skills, which is probably not 0 skills, but it's definitely not high skilled. And of course, you have to prove anything that's not unskilled. Those are the skills you have to prove are not transferable. Dimple says, I was looking at my doctor report after my rotator cuff surgery yesterday. And there's something in the report he wrote about me being able to grocery shop and do household chores. I never said that. Maybe you should talk to your doctor. I mean, just say, you know, I'm actually not able to go to the grocery store. I can't even drive, and I can't lift things, and I can't. I mean, maybe he's thinking you could do with your other. I don't know. Um, I mean, if he says something, I would expect her to be able to, and that's just his opinion. That you, given your army, like you could do that, but yeah, that seems kind of weird. Maybe have a little chat with him, gently, of course. Honey, not vinegar, right, Dimple? Gregory Petty says my last CDR, which was short from CDR, was in June of 2023. All right, so you said 3 years. It was in June of 2023, Gregory. When did it end? Did it end in June of 2023, or is that when they hit you up and then they were figuring things out for, 6 months? And so really it was December of 2023, and now it's going to be 3 years after. See what I'm saying? I mean, you got to kind of, not that they have to be exactly on the date anyway, and they usually aren't, never have been, I would say, most of the time. But that would be something to know. I mean, if it's going to stress you out. Says both SSDI and SSI. Yes, the SSI is going to consider, I think you're the one that was talking about transferring money away from you to parents and then applying for SSI. If the transfer is within the time period, I want to say I think it's 3 years. If it's in the last 3 years that you gave away money only to then go and ask for the welfare, they're going to count that money as if you have it and then deduct the amount of SSI so let's say you had, let's just say SSI was 900. It's more than that, but let's just say it's 1,000 and you transferred 4,000 to your parents. Maybe you were just trying to help them, whatever. Or, oh, by the way, if you owed them a debt, did you say you owed them a debt? That's not gifting away money. That's literally paying off a debt, like if you paid a credit card. That won't hurt you. Just make sure you have the documentation that it was a loan you were paying back. With both your signatures, they can explain, But if it was a gift, like, oh, I just want to give my parents this money because they're such sweet people and they need the money, that would be different because then you're giving away what you need to support yourself. And there is like a 3-year look back because some people will do it and then wait 3 years and then file. And they're like, I just sent $250,000 over here that we'll all enjoy later once they start getting my welfare. So, but the SSDI, it's not that huge of a deal, really, unless your SSDI amount is going to be super, super tiny. Because if your SSDI doesn't even have to be average, it could be less than average benefit amount. It's going to wipe out SSI eligibility anyway. The only difference is those 5 months of waiting period for the SSDI would have been what you could have gotten for SSI, which is now, about $5,000. If nobody's, gifting you shelter or anything, you've been responsible for it for yourself or loaned it and you got to pay back the old rent or whatever. So SSDI, SSI case, you have SSDI eligibility, obviously. So that's a good thing. And the SSI, again, if it's a loan that you like, that's another bill you're paying. They don't look at your monies and say, oh, you paid bills over the last 3 years. Now you can't get SSI. That's not how it works. And a loan, paying off a loan, whether it's to a credit card company, car loan, family members who loaned you money to help you get by, get it documented, what it was, and that it was definitely a loan, an unconditional loan, bona fide unconditional loan that you promised to pay back and then did. And then it should be fine. Okay? You might have said something about a loan. But if you didn't, then it would be gift and, Dolphin RD says, what can we do to help speed up this process, SSDI approval? Call our senators? No. The senators can't make the decision makers go, oh, I'm not going to consider all the evidence because they're rushing me, so I'm just going to have to say no. They're not going to do that. They're not going to put the thumb on that. What the senators are good for, when they're good for something, is if your case has been stuck in a cog, like it's not moving, you don't have an adjudicator working on your case for 6 months, or it's at the field office and never even got moved to the medical office, and you're like, they haven't asked me for anything, and it's not there, and I haven't gotten anything for it. I would first call the SSA and say, where is it at? And if they say, We're still sitting here. We're working on it. It might be another 3 or 4 months because we're slow. That's probably something. If it's been already 2 months and it's still at the field office, and they say there's nothing due from you, I would probably reach out to the senator and say, listen, they're either slow walking my thing in the field office, or it fell down a crack. It hasn't moved, and they say I have to wait 3 or 4 months for them to process it. That's kind of crazy, right? But you get weird clerks in some of these offices that'll say anything when they're not doing their job. So do not call your senator to say, I want my adjudicator to work faster. He has to follow rules of helping you get evidence. If you had strong evidence in front of his nose, which is technically our claimants, our burden to give them the evidence. I mean, we're grateful that they help us, but the point is, it's ultimately still our burden to get it in front of them. And if we're being slow, or your doctors aren't sending it when requested, you really want them to make a decision? Because guess what the decision has to be? It has to be a denial unless you've proven your case. So the whole rushing thing, when it's not something like a cog in the wheel, Dolphin, I think it's cutting your nose to spite your face. And I think as frustrating and as hard as it is to be patient, you really have no choice unless you want to cut your face. Makes sense? But if it is a cog in the wheel, darn straight, get those senators. And as I say almost every time, guys, look for, you got 2 senators and you have a House of Representative person. You can look them up very easily. You can also look up who is up for the next, who's the one up for the next re-election. And then sometimes I just think kind of off the cuff, like, I think that's the one we should ask, because they need the vote, assuming they're running for re-election. If they're not running for re-election, then no. But why not use the one that's a little nervous about elections and wants to please his people, because you're one of the people that can vote for him or vote for somebody else. Civil Chick says, might have got a few lesions on my brain. Oh, I forget a lot. I'm at step 3 for SSDI. All right, so this step 3 for SSDI, guys, if you're talking about the sequential evaluation process, which is what the medical workup office does before they can render a decision, that is the whole. Step 3 is where they figure out, do you meet a listing? If not, what is your RFC? It's really kind of like after they figure out you don't meet a listing. Then they figure out an RFC, residual functional capacity. What do all her medical records actually say in terms of what she can still and still not do? Can still and still not still do, despite her impairments that are shown in her medical records. They have a doctor inside looking at that. But they don't do that part until they have all the medical records, and that happens early on. So I had to retire January, too many impairments, have the Social Security and the DDS calling me and helping fill out forms. Yeah, not the best way to, they're not your advocate, just so you know. They're not, I don't know if that's a good idea, but the very Social Security people who are there to protect the funds and don't have time to be doing the secretarial work for you, that's not their job. I'm kind of surprised. I would really suggest you get somebody civil. Canova Henry says, good afternoon, Joy. Hello to you too, Canova. I'm wondering why, if my lawyer sent the hearing office in Philly my x-ray of my right knee fracture to show proof that I was disabled on July 24th to change my onset. Okay, I'm going to try to figure this out. And there's a part 2, he says. I'll try to find it. Okay, so good afternoon, Joy. I'm wondering why, are you wondering why, or are you wondering if my lawyer sent the hearing office in Philly my x-ray of my right knee fracture to show proof that I was disabled on July 2024 to change my onset. So I guess you went on a later onset and you want it to go back to July. And that's when you're fractured your right knee and there was an x-ray. From September 26, 25 to July 8, 2024. So do they found you disabled as of September 2025, but not July of 2024? I called the hearing office. They said it would be around October that I will hear anything about my case. Oh, so you haven't got... I'm confused. You have not had a judge's decision yet. Did you allege that you were disabled as of September of 25, and now you want to change it to July 8th of 2024? Well, why did you pick September of 2025? What was the evidentiary reason why you would pick that date? So that's what you need to know. Why that date? If it was because, yeah, I fractured my knee in July of 2024, but, I could have done sedentary work and, sitting in a chair, and I'm under 50 and blah, 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 or under 50. Yeah, I'm under 50. So, I don't know your whole vocational profile. That would change. It does not. Your vocational profile determines which rules apply to you. So, SST rules. So, when in doubt, send it in. But why don't you just ask your lawyer? Do you have my x-ray, and did you send it in? And why did you put, just ask him, why did we put September 2025? If I were to ever pick a date that was not like the first monetary date I could pick for my person, we've already talked about it. And if it was going to be some weird thing like, well, even though you stopped working in July of 2024 when you fractured the thing and you never went back, let's do a different later date because they could say the years. I don't do that. I always pick the oldest one. But, maybe they would. Like, let's say what happened in September was maybe that's when you stopped working. Maybe you were working from July of 2024 to September of 2025. So you weren't really disabled from working. You just were impaired. And you were still able to do whatever job they gave you. I don't know your details, but you want to find out if you're thinking it should be an earlier date, why it's not. And there's probably a good reason for it, but all right. Adam Salt is in the house. Good to see you, Adam, as always. Richard, current medical issues are PTSD, depression, anxiety disorder, panic attacks, mild global, I'm going to say it wrong, parenchyma volume loss, mild cognitive impairment, migraines, headache, obstructive sleep apnea. Okay, so mostly all the mental things, barring migraines and headaches, not physical. It's very hard to win just on medical, as you probably know. And you can't, if you're over 50, you can't even use the grids if it's only, you have to prove that you have a reduced RFC to the RFC maximum allowed for your age and still be found disabled. So that's not going to, he has more though, hold on. Be enough to say. Chronic sleep impairment, insomnia, dissociation, obesity, hepatitis, chronic fatigue, cervical spine, degenerative disease. Degenerative disease is what everybody has. Probably everyone over 30, 40. And they still work with it unless they can't. So you kind of want to figure out, if do I just have garden variety degenerative disease in my cervical spine, which we all do, or do I have something so severe that it's going to cut out a lot of physical jobs? My lifting will have to be under 20 and I'm 52. That would mean that that could mean that you could do light work potentially. Does it limit you to only lifting up to 10? That neck? Is there medical proof of that? Does the doctor say it and say it and say it? Then even at 51, you could maybe arguably be disabled if the SA is going to believe your doctor's opinion on that. They might say, we think you could lift up to 20, not 10. You just don't know. Richard says, I am rated to the VA. Thank you so much, Richard, for your service. I am so grateful. I can't even express how grateful. And that's a fact. I'm rated to the VA as, so I thank you, as UI, okay. TDUI, TDIU, unemployable basically, and rated as homebound on the SMC scale beyond 100%. All right, so now if you can get current, that's That's back when they VA rated you. Now, what about now? Are there doctors now that treat you that will talk to those specifics, not your ratings that they were, a couple of years ago, but getting treated for all the things that give you these things to show that they're still that severe? That would be an avenue. Because the SSA is not going to buy it just because they say it. So you have to keep getting that treatment, follow up, vigorous, not every 6 months, something, like all the things that are impeding you. Occupational therapy is like the neurocognitive kind, could be good too. Civil Chick says 59, widowed, work history 29 year. Yeah, they only care about the last 5. I know, we like to talk about we like to pull Hal Bundy's, right, Civil? I do it too. I've been doing this for, remember Al Bundy when he'd talk about things from his college days, like he was still living in the past? It was kind of funny. Or maybe it was high school. Yeah, I bet you it was high school. Didn't he play football or something? And he was always talking about that. And it's like 30 years ago. Well, probably for him, he was probably a lot younger than I'm thinking. He was probably, in his 40s during that show. But yeah, so they only care about the last 5, which is good, because otherwise you'd have to prove you can't do every single job you did going back, even the super easy ones. That would make it harder to win. So when they shortened up the 15-year look back to 5, that was so great, guys. That was truly like a permanent Christmas in July. It's like the gift that keeps on giving. Miami Heat says, when you have an attorney, does DDS reach out to the attorney if they have an issue getting medical records? The DDS people are so inconsistent. Attorneys do or do not give permission for them to reach out to you. I deny them permission to reach out to my clients. I want them to only go through me, but some attorneys want it the other way. The field office and the DDS staff routinely ignore that, even though the rules say if an attorney says don't talk to my client, they're not supposed to. So they violate it all the time. So it's like a toothless rule. It burns me up more than I can even express here. So I spank them a lot in writing. But, I try to be nice about it. But it's probably a little condescending on my part. But it gets me mad, because I've seen where they have reached out to ask questions that are the kind that will flip that case in the negative on my client. They'll manipulate the answer out of my client, and it's not the right answer. So it gets me really mad. What they historically do when they're doing their job is when they can't get them, yes, they can reach out and call. They should be calling the attorney, unless the attorney says, leave me alone, call my client directly, which is insanity. But they also often used to send a letter saying, we're trying to get this from so-and-so doctor, and he hasn't responded. Can you please call him? And that's awesome, because then we shoot him a letter. We don't make phone calls to your doctors. We're not going to ever get in the middle of, risking, ticking him off. But you can call your doctor, since it's your doctor, and say, listen, I need you to respond to these, this request. It's really, really important. And then they usually do when it's their client, because their patient, because I think they could get themselves in probably trouble if the patient ever wanted to push it with their I got knots, guys. Sorry, medical medical boards and stuff like that. I mean, that's kind of a negligence of sorts. Yes, I would say medical facilities typically do respond to the DDS, but let's say 10% don't, or 15 or 20%. So most of them do, but 10% falling down on the job is that can destroy 10% of the claimants, right? Yeah, I think you're asking what percentage of medical facilities. Do you think I'm a statistician? My goodness, come on, Miami. I just threw out some pretend stats. I think most of them do. I think some of them don't respond timely. They're just disorganized. But I certainly wouldn't be able to give you a stats look on that, because how could I give stats on the entire country? I'm not in everybody else's files. I don't know anybody else's business, right? And the SSA wouldn't know that answer. And, so there's no way for me to know. And I think maybe just wanted a roundabout like I gave you, right? Okay. Dimple says she orders 90 to 95% of her groceries for delivery. That's good. Are you still doing that? So does that mean 5% of the time, 10% of the time, you're still going to the store after your surgery? Surgery just happened, so probably not, right? You're probably home recovering. Excuse me, there's a door. If you open it, close it. Thank you. I'll be the boy child. Richard says alleged onset date was April 13th, 2023. Last denial date, May 12th, 2026. So you just got denied. SSDI coverage window, and you got till 2029. That's good. That's good. Were you the one, Richard, asking about whether you could refile again or FTC? You can do both. I think that was you asking, right? Miami says, does DDS reach out to your attorney if they have a hard time? This is a repeat question. Do you think most initial denials come from lack of medical records? Yes. All denials come from, I wouldn't say lack of medical records, lack of proof within whatever medical records show up that it is severe enough for the duration needed to be to render you disabled under the rules that apply to you. So it's the foundation of evidence is the medical records. So when people say, well, I'm disabled, I had an x-ray 2 years ago, it showed bad arthritis in my back, that should be enough. I'm like, I have to really withhold back from laughing, because I'm like, go ahead, keep preaching that, but you're going to keep losing. They have to be really vigorous, because if it was arthritis in the back, then every single person, including myself, would be on disability and we wouldn't be working. We'd all be on disability. So it is, I'm driving it home again, guys. Treat. You have to, if you have a lawyer, find out where the strong areas are to treat. I know we kind of touched on this at in the very beginning with our clients. A lot of times in my initial interview, you're going to want to get that neurology in there, blah, blah, blah. Anything that I can hear from what's going on. And it is something that people procrastinate on. They totally do. And, if they get their initial denial, sometimes they perk up after that. But, you can't make the cake without the ingredients, guys. And you guys are the only ones that can get the ingredients. And the ingredients are all what's in your medical records, because you keep going. Diagnostics. If your MRIs and stuff are pushing 2 years, that's too old in my book. I'd be getting updated MRIs if you have that bad back, because degeneration occurs, and degeneration is in terms of your case is your friend, because it keeps going. And I hate to say it, we keep getting older. So, don't make the mistake of thinking, yeah, but that's not from my workers' comp accident, and that's not from that car accident I had, and that's just, typical. Everybody's got that old age. I'm like, yes, but you can use it for your case. You've got to show that it's, it and everything else can cause you to be unable to do any job full time. Right? What you doing, Tosh? Tasha. Look over here. There she is. She's doing her little waddle. Nibble says, just got a call from the doctor office to check on me, and they interrupted my message. Oh. I'm not sure what that means. The message here, or when you were talking to them, they interrupted you? Not sure. Oh, your message here. DW is in the house. Perk interview in a couple of weeks. All right, good. That means you prevailed on your SSI claim. You're found disabled. So that's awesome. Am I supposed to mail bank statements and other docs to the local SSA, or just have the docs here with me for the interview? What do they say? If they don't tell you to mail them, then don't. If they said they want them mailed, then you would. And I wouldn't mail them. Well, if you do, mail them like UPS, FedEx, or if it's USPS, certified mail return receipt requested with the green card coming back to you. And I would fax it. So you have a fax come from the same day. They have it in some fax receptacle. Whether it gets to the right person in a number of weeks, we don't know. That's something I think they need to improve on. Does grid approved cases use full perk? Of course. Perk is about seeing if you're financially eligible for SSI. Nothing to do with medical. It's about if you're poor enough. So we'll see. Fingers crossed for you. Hey, Jen B's in the house. Hi, Jen. Hi, Stephanie. Happy Wednesday. You too, my lady. So if have filed for both SSDI and SSI, if SSDI gets approved, then so will SSI. If asset requirement, assets is the countable resources, which is probably what you meant by assets, and your income. So remember, if your SSDI is high enough, it's going to boot out your SSI for any months you got the SSDI. Applied February 2021, onset date June of 19. So the SSI never goes back to June of 19 if you filed in 2021, but your SSDI could feasibly go back partially. Yeah, because it's 619, 620. Yeah, you're almost like at that 17-month mark for the SSDI. So you might not lose any back benefits with SSDI due to delay, but the SSI never has retro before the date of application. So if you applied for SSI on February of 2021, that would be the earliest possible you'll have SSI coming to you. And if they found you disabled back when you thought you were, June of 19, you will have SSDI effective the 6 months thereafter. And you wouldn't, well, unless your SSDI is really low, like you didn't have a really robust work history of income, the SSDI, if you did have over, say, $1,000 of SSDI, you're not going to get SSI anyway, because that would be a countable income source that, you know, you already have 1,000 from SSDI. You don't get it from the taxpayers now, you know, you get it from your own insurance that you worked and paid for. Windfall offset, it just means, yeah, you can't get the welfare when you have more income. It's not a windfall offset. It's that you're not eligible for the SSI if you have other income in any of those given months that would boot you out. Now, let's say your SSD was only $500 a month. SSI is well greater than that. It could make up the difference, assuming you don't have other incomes, no in-kind stuff being gifted to you, like shelter. You know, that's all going to take into account. That will be in that perk. That's one of the things they're trying to figure out. So yeah, the SSI is going to depend on the resource requirement. That's the countable assets, countable resources, the assets. That would be like money sitting in the bank, 401ks. If you have a second piece of property, that's an would be an investment property, even if you're not using it for money, but you don't live on it. A second car in your name. If your name is on someone else's bank account and you forgot, like your mom's or something, get it. You know, you're gonna have to get it off and then, you know, explain to them that it was on there and that if you never used that money, it was just there as a safety net for your mom in case something happened. This is probably not you, Jen, but it happens to other people. You can do some signed certified statements that say, yeah, her name was on it, but your mom's saying, but that was only because, you know, it was in case something happened to me. But she had no permission to touch it in the meantime. Or sometimes it's like, she's only allowed to use it to go buy me stuff that I needed because I can't get out there. Something like that. But she have to pretty much attest that she had no power to take it for herself, never did take it for herself, blah, blah, blah. Sometimes then you can get over that, but it's entitled in your name. If that's the case. Because that happens a lot. Parents will put, especially as they're getting older, they'll put their child's name on it so that if they become unable to pay their bills, the child will be able to do it for them much more easily. Okay. Sunshine says something about 14 years. I don't remember what that's in reference to, Sunshine, but then Sunshine goes off, continues to say, I'm wondering, is that how old your degree is? Are you the person we're talking about degrees, Sunshine? I'm a family nurse practitioner, but cannot work now. On a feeding tube. Oh my goodness, I'm so sorry, Sunshine. I weigh less than 100 pounds. Oh my goodness. I'll pray for you there, sunshine. I forget if you said you have a pending claim or thinking about filing. I assume you have a lawyer and you're getting them to do what they need to do for it. If you don't and you need me to run it through with you, just feel free to go to the website and fill it out. Just tell them that I spoke to you on here. Mention your screen name, Sunshine, and the peeps will get it right to me. No additional eval for a waitlist per se, because I have a feeling that would be accepted. I don't know. Lillian Arocho. Hello, Ms. Joy. Stephanie, all things Social Security. Don't forget to subscribe, like, and share. Thank you, Lillian. Are you La Rocha that used to have the lily as your picture? And did you change your name? I'm just wondering if that's you. And see the flower is gone, and there's looks like a woman and two cutie pies with her. Elliot's in the house. Hey, Elliot. DPD. TPD. I'm having a brain fart there, Elliot. Half Pint says, hi, Stephanie. I hope you had a great Mother's Day. I was doing my colonoscopy prep. So let's just say I wasn't allowed to eat the whole day. I had some bone broth and some ginger tea. And then I was spent a lot of time in the bathroom, as you can imagine. But it wasn't a bad day. I mean, seriously, it wasn't otherwise, a big deal. I just wanted to get it over with, the next day. And then I wanted to eat. But then when I was done, before I went in, I was really hungry. And then when I was done, and since I haven't really had an appetite, so trying to just eat really good, Sybil Chick says, I had a pain doctor put in my notes I smelled like cigarettes. You didn't have him do it. He just did it. I don't smoke. So you're around someone maybe and it got in your clothing. So I was demanding a test from my primary doctor. I was growling. They didn't give me the test. I was mad. That is so appalling. I feel for you, Sybil. I mean, people can smell like smoke. It doesn't mean they smoke. I remember when we used to go to our American Legion, and I quit smoking a long time ago, like in 2000, and I was quite a smoker. And they used to be in our East Stroudsburg American Legion, people could smoke. Then they stopped it and they made an outdoor hut that people could smoke. And it's kind of cute, which is really sweet, because people have their addictions and they come there to relax and all that. I didn't have a problem with it. I didn't really have a problem with stinking either when we would go in and have a drink. But we didn't wear, the clothes that we wanted to stink. We were really careful, like, oh, we're going to Legion, so just wear that T-shirt, Otherwise, because I used to smoke, this smell doesn't bother me at all. I mean, I don't want it in my clothes, but, it's kind of a little reminiscent of those crazy younger days. Yeah, it was bad. All right. Yeah, I don't know what to say about that. Like, maybe if you talk to him next time and say, I don't know if you're still seeing that pain doctor, but maybe talk to your PCP and be like, well, I don't smoke. Look at all my records. And they put in my records that I smelled like smoke on this one. I assume it was just one day. I don't know if I'd been I don't know where you live, but on the bus next to someone who would smoke. I don't know, but I don't smoke and nobody in my house smokes. So I'm wondering if I had been someplace beforehand. I just don't know. Like whatever it is, that maybe it can get a little in there that you are refuting this, even though you're. And it's funny. They're not going to test you for it, but they should put in the records if you ask to say patient refutes any indication that she smokes. Says she does not smoke, and they put in there. We're putting in her statement because she asked us to. They don't necessarily have to take out what they found. They found you smell like smoke. The question is why, right? And just something else. Is there something else? Maybe you guys know. Is there something else that can give a smoky smell, even though a person doesn't smoke? I wonder. Like maybe you were at like a cafe or something, someone is smoking next to you, or you were in a place where people could smoke inside. I don't know if there are any such places anymore, but although I know that certain private clubs you can, like the American Legion up in the area where we're moving to, they still smoke in there. Now I don't think my husband's gonna really want to hang there because it's a little dark and dingy, and ours here is a little more bright and I don't know, cheery. But so even when I go up there, we don't go there, which is a shame because I would like to go to the American Legion. It's cheaper, but I like to give my support, So we'll see. We'll see. I mean, obviously there are people probably that so many of them smoke that they don't want to do it, and I get that too. I mean, it is their place to relax and enjoy. It's certainly not up to us to define how they do that, given particularly that we are newcomers, So Elliot says the look back period for most federal and some state programs is 3 years. Yeah, there's something about a 5-year though too. No, I don't think it's with SSI, so I can't speak to the state stuff, Elliot, but I recall something. Does any of you guys know about it? It might be something Medicaid related, and that would be state oriented. We could find out. I'm sure that's a pretty easy search to do. My tortoise she keeps trying to go under my chair. So notwithstanding some exceptions and carved out in statute. Yeah, so there's I would say that's probably true. And then you have those less common areas where it might be 5 years. I steer clear of that stuff, guys. And leave that to others. All right, so Elliot is sharing what he thinks may apply, and it's section 1613C. How about it, guys? Independence resurrected. Hello to you, Independence. Sybil Chick says, okay, question. Collecting my retirement presently. Okay, so you're 62 or older, right? Why did I think you said 60? I'm mixing everybody's ages up. Sorry, guys. And had a bulk payment for non-spouse. I don't know what that means. Do you mean you had a bulk payment for early retirement on your own work record? Could this possibly make this year a new high? No, that's not earned income that you pay Social Security taxes on. Yeah, it's not only just income that you have to pay taxes on, you have to pay Social Security tax on it. So we could pay income tax on capital gains earnings, like your stock goes up, you sold it, now you got to realize gain, you got to pay tax. That's not Social Security taxed. It's income tax. However, those kind of incomes get taxed, usually higher, right, than our working income, kind of. But that's not Social Security tax. So that does nothing to help your Social Security rate. And neither does getting retirement, because that's not worked income either. It's all about what you worked and paid into Social Security for, right? So that because Social Security is supposed to replace a portion of your monthly earnings that you used to earn. A portion, by the way. People go, how can I live on this? I used to earn this. Well, it was never supposed to pay you what you earned. It was supposed to just pay a portion. It's supposed to add to your own plan to save for retirement, not cover it all. DWS says, do you believe the 2,000 asset resource limit for SSI established in the 80s ever be increased? There's so much push for it, and I hope it gets increased, DW. I can't imagine that it's not going to. I'm not sure who the holdouts are. I mean, I think there's bipartisan that want to do it, and then there's others bipartisan that will not lift a finger to make it happen. So both sides of the fence, maybe because they know it's going to cause more to come out of the general fund, which means everyone's taxes have to go up. So, but the point, I mean, I always go back to this, and I preach it like a preacher. I'm like, if 2000 was acknowledged by the legislative, Congress to be, or however it was set, to be necessary as a little cushion behind a person who's otherwise poor and with little to no income, and therefore would be eligible for SSI. How can you not say that should be going up with COLA at the very least? And how can you say it's sufficient now and not a total travesty? It's inexplicable. Inexplicable. Don't get me started, TW. I think it should go upward somewhere between $6,000 and $10,000 tomorrow. And I would be happy with any amount in that range. I know some people are like, it should be 50 so they can. I'm like, no, it shouldn't be 50. Because most working people can't afford to save 50 because they keep paying the taxes to pay everybody else to, keep the disabled, floating that didn't prepare for their own, situation. And they can't save 50. Most people do not have $50,000 saved in the bank. But then they're saying, keep paying to support this person, and this person can have 50,000 in the bank. Do you see where that kind of would be wrong too? But the 10,000 or less, I'm totally on board, and I think it should have happened long ago. Sybil says something about the special census stuff. Okay. Meeting it. Independence says, I had a bar of a CDR hearing. I know this will sound unbelievable, but all your acronyms are really flying over my head. The entire something and something were falsified. Okay, those mean nothing to me. Even stated I didn't attend hearing, then fabricated entire something else as a result. You got to stop using acronyms that you make up or that are not common in every place, because it's just not gonna be understood. So it sounds like you got a decision of denial after an ALJ hearing on a CDR. So you were denied on initial recon for the CDR, went to hearing, and then he denied you too. And then in the decision, he said you didn't attend the hearing. That is weird. What does your lawyer say about that? I don't know. And I can't really speak to the rest of your stuff because I don't really know what those things mean. Elsa says, I transfer of funds, SI transfer of dollars for hospitalization. So, all right, you're not being clear there, but I think you might be saying when you gave the money, are you the one that gave it to your parents? You gave it to the parents because they footed the bill initially and it was a debt that you owed to them? Then get that in writing. You could have it in writing from them. You could attach the bills that they paid that matched up exactly with what you paid them back. And if there's something else, like plus they threw me $200 a month because I was literally had no cash. Whatever the reality is, if they're going to sign off on it, certified under oath, so to speak, and you do, that can be really helpful. If they can even imagine if they produce the checks or the credit card statements that show that they paid your hospital bills. They did it in some way, and I'm sure they have a receipt, because what if the hospital were to come back at you? Like, you never paid. Yes, I did. So all that stuff can really go to town. It can, and the receipts of them paying it, as well as the certified statement, are like the receipts themselves are the extremely objective proof. They have the check. In the memo, it says to pay John's or whoever Elsie's hospital bill of $519, $3,000 to it, So you can do it. You're just gonna have to get organized and get that paperwork together, and keep a copy of whatever you submit. Keep a copy with you, so that if they say they didn't receive it or you have to appeal, you know what went in. Transfer, no worries. I think I got what you're saying. Is that, did I get it right? I'll say. Canova says, I'm approved for disability for my SSDI reconsideration claim, but they said I was disabled on September 26th before my 5th. Oh, so your birthday is what, the 27th? Yeah. So what they're saying is you were able to do light work. You were really restricted all the way down to light work. At light work, you could not win before your 55th birthday, because to win as a 54-year-old, you have to be so disabled that you can't do more than a sit-down job physically. You turned 55 September 26th. And it sounds like you appealed this. Chance of it getting overturned, probably slim, but chance of it getting overturned might be slim too. Are you guys following this? So He was awarded as of, he didn't get the date he wanted when he was in his early 50s. He got it when he turned 55. That's where they drew, pulled the onset date up to. And it's because they said he's able to do light work. At light work, you can be found disabled at 55. You cannot be found disabled at 54. All right? It's the rules that they get. They're less stringent about winning as you get older like that because they realize that at 55, your ability to adjust to that, lighter sedentary job that's not with your skills from before is going to be very hard because us old coots, we have a hard time adjusting to new things, right? So that's where that all comes into. It sounds like you appealed, and then you're thinking of having a hearing somewhere in October. So you have to just prove that they were wrong about the light and that it's sedentary, even at 54. Like all your evidence points to sedentary and nothing greater than that. You could not live up to 20. You could not lift up to 20 pounds. You could not be on your feet 6 out of 8 hours. Either one of those things, if you can disprove one of them, it gives you a good chance of, prevailing on your appeal. It's not easy though. The judges like to affirm those things, particularly when you know you're already covered. You got your benefits. Blah blah blah. They save money for the SSA fund by not giving you everything you demanded. That you thought. Independence says, right? Just so you know, guys, we're at 2:16, so we're a little over halfway in. Oops, sorry. Independence says you have POMS. Blah blah blah. Okay, nobody memorizes their numbers, just so you know. Possibly to get a medical improvement not expected mind diary. Well, yeah, a lot of people get mind diaries, like the grids, but could be younger. No. Grids only apply to being found disabled, not about the diary. But unless what you're trying to say is by the time you get your CDR, you might be in a different age group to which the grids apply at all, which maybe they didn't before, or when they're doing the CDR, and it's a great point. Or sometimes you won at 52, you have a CDR, it's even easier to win because now you're 55, and they have to prove that they even have to prove something harder for them to prove than when you win at 52. So I think that might be what you're talking about. But better to just explain it than to try to throw in numbers because no one memorizes them. No, there's always new ones coming along. It's best to just research, Don Mogi. How long does it take for a windfall offset? Hi, Don. In reference to back payment. You're going to have to tell me about what windfall you're talking about and what offset. Because as you might know, the WEP, windfall elimination provision, no longer applies. The WEP. So maybe you're talking to something else. I don't know if you are. All right, you got a few of the same thing here, Don. You're kind of spamming it. I'm going to delete some of them so they're not clogging things up. You probably didn't know that it posted all those times. Maybe you didn't see it. And then you posted it again because you didn't see it. That's okay, though. So I'm not sure. There's no windfall offset that I can think of that you could be referring to. So you might be misnaming it. So just let me know what you mean. Do overpayment, this is user. Do overpayment waivers ever work in Houston, Texas? Yeah, they're not based on the town you're in. It's federal. So rest assured, it's whatever the federal law says. And it applies to every field office and whether they're going to, or whichever office makes the waiver decision, but it's a federal law decision. And yeah, it can work there just as well as any place else. It's whether you meet the criteria of a waiver. Just applying for it doesn't mean you get it. And El Michelle says, hi, El Michelle. I don't think we've met. Hi, 45-year-old therapist with had coronary artery disease. Would that be neuropathy, fibro? I assume you mean fibromyalgia, but there's other fibro starting names. Spondylosis, chronic fatigue, pain, intermittent FMLA, and fluctuating symptoms affecting reliability and stamina. Still working but struggling. Okay, so you're still able to work, and that's the bottom line on that, just so you know. And I know, I will say this, you have a really tough case at 45. Spondylosis is pretty common, doesn't prevent sedentary work for sure, probably doesn't even prevent light work. Your work right now is probably sedentary if you're a therapist, unless you're a physical therapist. Coronary artery disease is not going to refute a sedentary job. We all know that pain from neuropathy, chronic pain, and fatigue can. However, because the pain is subjective, particularly for the chronic pain and fatigue, it just is a real hard thing. I'm just talking realities here about the outcomes and the findings by the SSA. It's very hard to get objective proof of that, besides just saying it's so. They'll say that they believe it to be true, but that the record doesn't support how severe it must be for you to prove all jobs are off the table, because you have to prove all 12,000 jobs, Michelle. Of course, you're still working, I assume, over SGA, perhaps even full time, so you can't even apply right now. And the concern I have, and I would say this for a lot, like 45-year-olds in general, unless certain really severe, objective, almost listing level type of things, if you stop working now to apply, if you stop fully working entirely, your DLI is going to start to toll and possibly end before 50, or maybe shortly after 50. And 50 is not an easy age to win it either. It's just slightly easier, depending on the impairments, and not easier for many other impairments. I wonder if it would behoove you to consider if you can do this with your career, dropping down to part-time. If you need to stop, if you could do some amount that will keep getting you your credits, so that's like definitely under 10,000 a year to get all 4 credits. And I'm using that as a conservative number. It's quite a bit less, but I don't know when people are listening to this, so every year it changes. And if you're self-employed, you have to earn a little bit more to get all 4 credits. My concern is that you quit working, you file, you get denied. Next thing you know, you can't file anymore because you haven't worked, and whatever happened, your DLI is now over. It's in the past. So, and all you've done is get denied. They acknowledge that you are very impaired, but you could do light or sedentary work, and you can't win with that. So if you could somehow keep working enough to get your credits and enough to continue working, and it doesn't have to be under SGA, because you wouldn't be filing now. You would just be cutting back significantly if you can afford to do that. I mean, like going to 20 hours a week or something. And maybe you need like flex hours too, because when your flare-ups occur, it's got to be pretty bad. Just something to think about. And I'm just saying it, not just to you, but generally speaking, when you're under 50, and again, I mean, it can, depending on the issue, it can be over 50 also. You have to be able to prove that you meet the rules that apply to the age, and it's very, 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 very stringent at 45. One of the benefits, Michelle, of doing it under SGA, if you can afford to live on under SGA for the next 5 years, so like make $1,600 a month, say, is that by the time you get to when you apply, let's say it's 5 years from now, if you pick the date right, you will have no past relevant work. And I say that because as a therapist, you have really high skilled work and sedentary work. And that's very hard to win with at, 50, 51, 52, 54. But if you do not have SGA work in your last 5 years, then you don't have transferable skills. I mean, it's a technical thing. So that's another idea for you as you plan forward. I mean, just things to think about. I mean, yes, you can totally stop or work under. Second you go under SGA or stop, you can file. I just think you might be seeing a lot of denials. And I'm not trying to dissuade you from filing. People get caught up, I just want to make you aware of the burdens and then what it does to your ability to file when you might have had a better case. That's all. All right. And I hate having to say that to young adults that are under 50. Michelle says, how does SSDI evaluate cumulative fluctuating conditions while still attempting to work? Well, A, if you're still attempting to work and earning SGA, you can't file. Because that's the first step. Step one is the person working SGA. They look to see if your medical evidence strongly says that you would be unable to work. Usually it's termed, because remember, sustained work means 8 hours a day, 5 days a week, or the equivalent. It's sustained. You can't just be able to work 4 hours for the day as a therapist. And they say, you're not disabled because you're working every day. If you can prove that that is the most you can get at, and you got to do that through the medical records, your statements must be not inconsistent with that, but it's going to have to be through all the medical records, like proof that the fatigue just takes you out and you just can't function. It's very hard to prove that, Sometimes it can be through some sort of occupational therapy that, sees at what point using the brain gets you fatigued. It's unique to every case. You have to, it all depends on the person's treatment, their records, and then you kind of have to be really aggressive with continuing treatment to get better, which as of now, they don't have cures for most of these things. So, or things that will alleviate it, even if it won't cure it enough to go back to work. That's usually work full time, sustained basis. That's usually kind of tenuous too. But the argument for the cumulative fluctuating conditions often involves around cannot do it on a sustained basis, cannot do it on a sustained, but it's very hard to prove, particularly for a lot of the mental cog stuff. Independence says, even on a sedentary level, say you have non-exertional medical side effects, edema level, you consider stand for even a few hours a day could help. Oh, could not. I think you meant, you said can't, right? Sit or stand. My eyes, see that, Independence? I'm going blind. You can't sit or stand for even a few hours a day could help. Yes, and I say with the edema, we talk about leg elevation sometimes, because there is like a SSA tactic of saying, well, she can't sit that long in one fell swoop, and she can't stand that long, but she could sit and stand and alternate at will. And there are jobs that allow you to do that. That may be true, but what if you can't actually be upright, sitting or standing, because that edema that goes to your feet, you have to be reclined with your legs up to your chest. The trick is getting the proof that you need that. Mere edema isn't going to be the proof sufficient. That's just going to say mere edema. And so at the end of the day, she puts feet up. It's where you probably need medical advice saying, I really think you should, and it should be in writing. And repeatedly, like not just one time when they get the suspicion that you asked your doctor to stick it in the record. If it's consistently, and then you're reporting back like, hey, I was doing it every 2 hours for a half hour, doctor, like you suggested, and it's still really bad. What should I do? And then the doctor says, all right, unfortunately, you're going to have to bump it up to maybe do it every hour and a half instead of every 2 hours. And let me take a look at your see whether we should adjust your edema medication. Maybe it's a water pill, who knows, So that can help too. But They're going to come. SSA is going to be kicking and screaming to come to that. It's really, depending on your age too, all that stuff makes a big difference. Canova says, I worked as a certified nursing assistant, a CNA, that's very physical, for over 28 years before I fell and fractured my right knee. How long did you say you worked, Canova? Fractured my right knee and hurt my lower back. That was my last day I worked as a CNA. Yeah, that's really physical. I could see them saying you can't be a CNA if you have continuing evidence of a problematic right knee, and continuing, meaning today, tomorrow, going forward, significant issues with your lower back. That would be through the diagnostics mostly. Your complaints, physical therapy records showing that they're not up to snuff. Sometimes multiple courses of physical therapy. Maybe you want a couple courses every year to show that, it's still checking to see if it's improved or whatever. And same definitely with the lower back. MRIs, what's going on with the lower back? Little aches and pains isn't going to do it. It might do it for CNA, but then you got all those other jobs that you have to disprove as well. So Just a Girl is in the house. Hi there. I think we did meet, right? I don't remember your picture though, but I feel like I know the name Just a Girl. Good day. Thank you. Question is, if I am on SSDI and Medicaid is paying my Medicare, do they go back in time for payment if I get an inheritance of a house or money? I do not believe so. I don't do Medicaid law, as you know. However, you didn't have it in the back. I believe it would only be going forward, you'd be taken off. But you're going to want to ask someone who practices Medicaid law. Okay? I say that's my gut. Like, for instance, if it was SSI and you get an inheritance, you don't have to pay back your SSI. You're just not going to get it going forward because now you have that resource. So I'd like to think that's the same way for Medicaid. Yeah, that would be my bet, but you need to double check. You need to double check. Independent says, my ALJ didn't even know it was a CDR hearing until after it started. Yeah, so he really didn't get to, they didn't prep him very well. Yeah, proceeded anyway. Well, he's got to proceed. And by the way, that probably means that most of his work was done after, Remember, he doesn't give you your decision usually at the hearing because at any of the time, because once they have the testimony, and they do it, everyone's different the way they do it. His people probably reviewed the case and said, we don't see a reason for an OTR. So therefore you have to have your hearing. Would have been nice if you knew it was a CDR. That's kind of stupid, but the result is the same. It's the same questions and the same findings that he has to find. So it's not entirely crazy. And then it's after the hearing, when they have testimony, that they relook at the whole medical file to see, where everything's at with this testimony now added. Does it, where's it at? But I know it doesn't make you feel good when he doesn't even know it's a CDR hearing, right? Civil Chick says, 2023 airlifted, lesions on brain, cochlear implant 2025. Cochlear implant can often get you an automatic year, kind of like automatic year of SSDI. Or I should say, of being found disabled. Intracranial brain aneurysms. Oh my goodness, Sybil. Fourth nervi palsy. Good. Goodness. Extruding a lumbar disc, affecting feeling, drop foot, bone. And you are in your 60s. I think you probably have a good case. Did you find it? Did they deny you, or where are you at? I forget. And Sybil always uses grocery store delivery. Dolphin says, SSA knew I had an attorney and they still would call me. I know, they do that all the time, and I get infuriated because I'm supposed to be the blockade, so that they're not bugging my person, not trying to slide in some slick questions, and not stressing out my person. The reason why I'm getting paid by my person in the end, if we prevail, is because I do this. You know what I mean? They're really disrespecting the claimant. I mean, it's not about me. It's about the claimant. That's who they're disrespecting. And it's like, And I always say, like, for the sake of my client's health, those phone calls are very risky or, detrimental to his health. So please don't put yourself in that position. You'll live to regret it. I don't say that part, but I get a little holier than that when they do that because it's an abuse and it's against the rules and there's a reason for the rules. Yes. Dolphin, I'm going to just read the rest of this. He says, I do not answer my phone if the number is not recognized. Excellent. SSA does not show on caller ID. Sometimes it does, sometimes it doesn't. Sometimes it's numbers I recognize as likely being SSA, like a 410 number or a 443 number. So don't answer your phone. Agree. We have voicemail, guys. My goodness, I got it. That was invented. I was like an adolescent, probably. Those little machines, remember? But certainly, there is no reason why anyone should be picking up the phone. There isn't. You got voicemail for a reason. And if you think your kid's going to call you, you know that number. You probably have it labeled, whatever your kid's name is. So let it go to voicemail. They'll leave you a message if it's important. And then if you have an attorney, and this is what my people do, you shoot me up the message, or they sometimes they'll take a screenshot of the transcript from their phone, or if they don't have one, because sometimes that doesn't work. They'll say his name is this, and here's his number, and here's his extension, hopefully, and then I make the phone call. That's just the way it's got to be done. Users pointing out, I think that age is degenerative. Yes, it is. And I am trying now to fight that. I am. I'm getting to a gym with a helper. Yesterday was my first day, so I'm a little sore. But yeah, got to fight that degeneration. For mobility purposes is my point. Independent says, the ALJ never was aware in my CDR that I am concurrent 1, you mean Title 2 and Title 16 since 1990. Thought my onset date was 2013 for Evelyn, not even that it was a CDR. All right. Okay. I'll take your word for it. But again, his job is to see, it doesn't even matter. Those details do not affect what he has to find today. So don't get yourself all, hanging on the fact that he didn't know some minute, irrelevant fact that's irrelevant to what he has to do that day. That's all I'm saying. He's not going to know your biography. He doesn't care to. And he can't. He's got work to do. So those details, I would not expect him to know. He knows how to look it up when he makes the decision. Okay? So don't get too hung up on the things that don't matter as much. All right, Independence? User says, people still fax? Yes, it's digital fax now. I know I have some people that have regular fax machines. But yes, faxing digitally is the bomb. You don't waste any paper, no ink. You have no fax machine. It's right out of the computer. It's excellent. And it doesn't have to go to an old-fashioned fax machine. It will come to that person's email, I think. I know if it's the SSA, I don't know how they do it. They have some sort of, probably the same thing, but they call it their fax receptacle or something. Or that's what they referred to it to me once. I upload all my doctor stuff on the SSA website. Very good. Keep your receipts. They give you a receipt every time you, do they show you a receipt, Civil, every time you upload something, so you take a screenshot of the receipt? And if they don't, I assume they do, but if they didn't, you could also go in and just screenshot the list of things in there, so you always have proof that it's in there. I'd like them to know when it got in there. So hopefully the receipts. Independent says, what happens when you appeal the ALJ's decision based on fabricated? All right, you're still using your acronyms. You got to get over that. Saying claimant never showed. What happens? Well, if you prove yourself, you're going to get a remand probably. I mean, if he, FFCL, whatever the heck that is, independence, you really got to start spelling things out. But if let's say you're saying fabricated conclusions, well, if he didn't pinpoint cite to his the part in the medical evidence of record, the MER, section F usually, the exhibit and the page at which he found that quote that he just put in there, and he just says it was said, and there's no, that's probably going to be a remand, because that's called fabricated. There's no evidence that it's, he hasn't pinpointed it, or at least if it's definitely not in there, let's say he didn't pinpoint it, which would be weird, but sometimes they just use like at 12F, which is annoying because they want us to pinpoint. If you didn't even put where it's at and just says the medical records keep talking about da-da-da, and they never cites to it, and let's say it's not, the quote he says is not in there, yeah, then that would be fabricated. Now, if you don't like his conclusion based on actual things that were said in the file, you don't think they equal up to what he said, that will be up to the court. Can look at the appeal panel or whatever and say, yeah, that was not based on substantial evidence. Now, substantial evidence does not mean all of the evidence. All of the evidence doesn't have to say that. Some stuff can say something else, but if there's substantial evidence that supports it, and that's what he's relying on, he's kind of allowed to do that. So it's really going to depend. So when he said claimant never showed, did he also then nowhere in the decision, and this is an important question, did he also say anything about hearing testimony and say claimant stated at hearing? Deep within the, I assume you read every line of your decision, because if he did, that means that was just a typo where he said claimant never showed. That was probably just from the cans, the template they have, which is weird. You think they would look at that. But anyway, I'm just wondering. That's just curiosity on my part. It's getting a little warm in here. Elsa, oh, that's very nice of you to say. You're very welcome. Okay. Sybil, I'm just passing on some of the stuff I don't understand. Oh, okay. Yeah. Hi, ENS. Hello back to you. Jenny says, how do they look at assets, living arrangements, etc., retroactively for SSI, though? Do they go X month? My only asset this whole time has been my 2013 car that is worth it. Yeah, so if that's your only countable resource, there's nothing in the bank. Usually people have $5 or something, or $5 in their pocket. So just be honest if you have that, because that's not going to hurt you. So yeah, they're going to ask you first, and then if something comes down the pike, where they find, I don't know if they do DMV searches or whatever, I really don't know, that you had a second car, and you know if you don't have it, so you don't have to worry about that. Living arrangements, they ask you also, and just tell them, like, if the big thing about living arrangements is, are you paying your fair share, or if applicable, the presumed market value, which is when that's applicable, it's only it's less than $400. So if you are paying that, or you can't pay it because you don't have your SSI yet or your SSD, do you have a loan? Is it being loaned to you, your shelter? Like someone said, yeah, you can live it. We'll have an arrangement. I'll spot you, $500 of shelter. You pay me back the $500 for however many months you live here, not being able to pay. And that would be proof that it was not a gifted in kind. If you have the sufficient paperwork to show this from that party, that would show that it was not gifted. You were not gifted in-kind income of almost $400 a month worth of shelter, because it was a loan and you got to pay it back. That way, if that's the case, then they don't dock you the 1/3 from your SSI total, which is nearly 1,000, and bring it down to 600-700. You get the whole thing. And then you can use that to pay the person you're supposed to pay, or, however that's going to work. So, I mean, the worst thing that happens, Jen Me, is that they dock you 1/3. But if you've been, borrowing shelter that you have to pay back at least X amount for every month, every month that is applicable to that you can prove, they should not be docking. Now, sometimes they ignore what you give them and you have to fight it a little bit. But if they're doing it right, you're sworn under oath statements to it. Your landlord, saying the same thing. Say what has to be said, accurate. I wouldn't suggest people fabricate. Then you should get the whole, say, the full amount of SSI for each of those back years to which it applies. And then you pay your debts accordingly once you get your back pay. User says, smoke reasons to smell like smoke. Got ride in car from smoker. Barbecue pit. I agree. Good ones. And that's what I think you were talking about, Civil. I think, no, maybe it was Independence that said spouse smokes. Yeah, I mean, that would definitely, if you hang out with your spouse and he's smoking, cause, the smoke to go in your clothing, for sure. But word to the wise, guys, change your clothes before you go to the doctor's office, because you might have a jerky jerk, like that pain doctor. And I shouldn't even say jerky jerk. When it comes to pain and healing, I think it's a medical fact that smoking inhibits healing. So in theory, if someone continues to smoke, they're contributing to their own disability if it falls in the range of healing from surgeries and stuff like that. Bad backs and stuff like that. So maybe that's why they're like, yeah, I mean, that could be. So I shouldn't necessarily automatically assume he's a jerky jerk. But why couldn't you just spoken to you about it instead? And then see if you stink like that the next time. Right? Delia's in the house. Hi, Delia. Sometimes vanilla smells like tobacco to me. That's why I never buy the candles. Oh my gosh, that's weird. Huh. We all have different ways of smelling things, I suppose, and different ways of tasting things. Like, kind of speaking to a nutritional counselor, not because I don't know a lot about nutrition, I do, but because of my, I don't know, very sensitive stomach these days. I wanted to see, I do want to see, I'm trying to tamper with the things I do like to eat and that I know are good for me. Which ones should I still have? Which ones should I steer clear of? Which things should I add that I can tolerate? Anyway, it was a little embarrassing for me to say I can't eat cooked greens because they smell and taste like farts. It does. And there are people like me. I don't know if any of you guys are, but since I was a kid, it has not changed. I don't know how people can be like, I can't wait to eat my broccoli. I'm like, are you kidding? Yeah, my dog has some dung over there, like that's just as bad. But, everything's different. So vanilla to me never smells like tobacco. But I notice when somebody here makes coffee, sometimes I get a smell of like a can of tuna. And I like coffee. It doesn't taste like tuna. But I don't know if it's maybe the grinds after, because it's a Keurig. Maybe, I don't know, something burnt maybe? Isn't that weird? Interesting to me. But yeah, so here I can't eat the green veggies because they smell horrific to me, which has always made dieting very hard. And those people that love it, like my husband, it's like not at all like that. So our taste buds definitely perceive differently, massively, right? I love tomatoes. I had a friend who hated tomatoes. Cucumbers. I had another friend who hated cucumbers. I like those. Civil chick. I don't know. Ugh, gosh. I can't remember what you're saying, the 5,002. You kind of have to give me a clue when you guys are responding to something after the fact, because there's just too much going in and out of the head. I'm sorry, Civil. Independent says, maybe I'm wrong, but if a claimant hasn't received forms, access files, and ALJ thought it was an initial, found out it was CDR. Yeah, maybe his assistant gave him the wrong information. I mean, you don't know. Found out it was a CDR, yet kept going. I would think that hearing would be, no, it's not poisonous fruit if he follows all the steps he needs to do to make his decision. That is the criteria. All right. So when you see his decision, did he follow all the steps needed to get to the decision? And if he found out, like, did he ask you all the questions he was going to ask you anyway? Then it's called immaterial. It's called harmless error. It's not going to make a difference. It doesn't look good. I know it feels icky, but yeah, so I think you're probably mistaken on that. But I mean, if he's an idiot, independence, then his decision is probably going to be flawed too. But if you see the decision goes through everything it's supposed to go through, which it can do, even if you don't like the result, sadly, but sometimes not. Sometimes you don't like the result, and they did not do something sufficiently. I mean, that's the things we appeal, right, to AC. Okay, you said claimant hasn't received forms. What forms are you expecting to receive? There's really nothing mandatory. Claimant didn't access files. I don't know why you didn't do that. That's kind of on you, not on him. So the only difference was he thought you were trying to prove disability, which you are, but you were doing it on a CDR and not the initial. It's not really. The analysis only changes when he's making his decision, not when he's pulling test. The hearing is only about pulling testimony from you and a VE. So as long as he did that, what he has to do after when rendering his decision kind of has no bearing. And I will say there's a little bit of a difference with the CDR and initial when he's making his decision. He has to go through different steps, but he doesn't do them at the hearing. That's later. So I just want to caution you against hanging your hat on things that would probably more appropriately be considered harmless error because they didn't affect the outcome of the case. And it doesn't mean you win or lose. Whether the outcome of the case is based on him following the rules when making his decision is what counts. So I just don't want you to be like, I don't have to do squat because I'm going to get this remanded because he was silly when he did this. That's not going to be your best strategy. All right. So I just don't want you to do that. All right. This is funny. User says, why does Social Security pick now to go after overpayments so hard? They're not. They've been doing that. I have so many videos over the last 5 years. But it started, I've been doing this for 21 and I have overpayment requests all the time. It's nothing new. A couple years ago, they made a big mistake. It was some sort of like political silliness where they said, oh, for overpayments, we're not going to collect them at more than 10%. So a rich person with an overpayment didn't have to pay more than 10% automatically, like 10% of his SSD each month. Obviously, that's not fair or right or financially savvy. So it was kind of an irresponsible period of time in the administration, the SSA administration, to do that. I think it was for political reasons. It certainly hurt the funds, so it hurt you guys. But that was, what they do sometimes when it's politics. So that had to be changed, of course. But the actual going after OPs hasn't changed a bit. Not a bit. Been going on forever. In fact, it's been, I don't even want to take cases with OPs because, well, I'll take them on consult. That's it. Representing is just, it's a headache. I don't regret any of the ones I did, and I'm very glad for the results. But you lose your mind with work, from my perspective. It's very hands-on. It's very thinking, outside the box to get proof of XYZ and blah, blah, blah. It worked, so did something right, but it took years and hundreds of hours of work and didn't get paid on it. And so, suffice it to say. But yeah, they've been hard hit as long as I've known, because an overpayment is an overpayment. And remember, it's coming from a trust fund. Trust funds are not just like regular bank accounts. People can just make, low-end people can make discretionary things like, I'm going to pay it. It's not like you're the accountant in a store deciding to issue a refund. It's a trust. There are criminal penalties that come with abusing the trust and the fiduciary duties. So it cannot be where, oh, you got an overpayment, you got money you weren't entitled to. We're just not going to have you pay back. They can't do that. The waiver program is when it would be so detrimental to you because you wouldn't be able to feed yourself or keep a basic roof over your head that they can waive an overpayment. And that's assuming it's not your fault, you weren't trying to skate or anything like that. But otherwise, yeah, I mean, might not be a popular view, guys, but overpayments need to be paid back. I do like to see that it's done reasonably. And by and large, if you're hard up, it is generally done quite gently. And if you feel it, the payment plan is not gentle enough, show why. You can always ask for a recalculation because something changed or you left something out. But they're not going to care about your credit cards. Your credit cards do not take precedence over you paying back the fund that is basically owned by a bunch of disabled people that they paid into it. So you got to kind of understand everything and not have a limited perspective of, me, and God, this is going to stink me having to pay this back. But when you do, just do a payment plan. And if you are on the poor side, it could be as low as I've seen in the past, $10 to $25. Of course, inflation has occurred. And that would be a month. I don't know if they're always going to want to go with at least 10%. That's possible. I don't know. But it's not that hard to get a payment plan that is doable. But it can't be doable. It's expensive. You having enough money to go, on a fancy vacation while the fund is sitting without the money that you took that would be going to other people. You know what I'm saying? Okay. Off the bandwagon now. What happens? This is Jenny Woods. Hi, Jenny. What happens if you're slightly over SGA, but SSA might believe medical records you have impairments? If you're over SGA, you're over SGA. So whatever the relevance of SGA is to whatever stage you're at, over SGA is over SGA. I would say be sure to look to see if you have medical, if you have the IRWIs that could bring down your income below SGA. Related work expenses, I think I have a video on that or two. You can also look it up. It's pretty common, easy to find. Doesn't often apply to people with SSA because they're usually on Medicaid and they don't have co-pays and deductibles. Someone else pays that for them, so they can't say this came out of my income. But SSD people, they usually have if they have like a, some sort of insurance policy that pays, covers their health insurance, but they still have co-pays, that can be helpful. It includes medical, if you have to pay out of pocket for some portion of your medications. And there's plenty of other things, but those are the biggies, I'd say. If you clarify your question any further, Jenny, I could probably give you more on that. Okay, so I think Independence is trying to say that he had this term that he likes, jurisdictional procedural history and findings of facts and conclusions of ZLA. Maybe he meant conclusions of law, maybe. Yeah, I wouldn't go with that acronym. Nobody uses it. I wouldn't do it. It's okay, though. I get it. Typos, JPH, jurisdictional. Yeah, we don't use that. Nobody uses it. Just saying, and me, I've been doing this for decades, so. Yeah, I would just say the facts that were found. Sometimes we say findings of fact. But yeah, using it doesn't really speak to what your issue is. ENS says, had my hearing last week and I think it went well. Called SS today and they told me it's in the decision writing stage. Okay, that's where it goes next. Please pray for me on this one. I will pray for you, ENS. And positive thoughts. And I bet you people here will too. So fingers crossed for you, my friend. Yep, Sybil says she's praying. All right. Hey, Michael Holland's in the house. Hi, Michael. Good to see you again. He says, hello, Stephanie. Thanks for putting out these videos. You are really welcome. You are truly a joy to listen to. That's really sweet. I'm sure my voice gets a little grating at times, particularly when it gets hoarse like it does by the end of these. Pun intended. Yeah, the last name. I get it. I have learned so much from listening to your videos. Thank you, Michael. That is, and your comments, I suppose, is what you're saying. That's really sweet of you. I appreciate the kind words. It's very nice. I'm just trying to bring this up. Kathy Clayton's in the house. Hi, Kathy. Ulnar nerve, CE doctor noted can't sit, stand, and lift no more than 10 pounds. Ooh, that sounds good. That sounds good. If it's particularly CE doctor. And hopefully your doctors kind of have supportive records to that. So they don't have a reason to disregard the CE doctor and think he's being too, what would I say? It's a underestimation of her capacities. I've seen adjudicators write that, even about their own CE. It's very convenient. User says, thank you for responding, ma'am. You're welcome, sir. Or ma'am, I don't know. I'm thinking it's a sir. But I could be wrong. No offense. Kathy Clayton says, how does transferable skills work? Age 62. I have a video on that, so I'm not going to go through the whole thing right now, okay? There's total video on transferable skills, if that works for you. If you put a question in the comments and say, can you show me? I mean, I think you can even, there might be a playlist called transferable skills. That I'm not sure. But it's in the title. It would be transferable skills in the title of the video. So if you search on that basis, which I think you can do, you'll see them come up. You know, in a nutshell, though, when you're trying to grit out, which you would be doing at age 62, Kathy, you have to prove that even you can't do your prior job, you can't do medium level work, you've got to be relegated to light or sedentary, can't do your prior job, and if that was a skilled job or semi-skilled job, you cannot transfer those skills to one of those jobs in the light or sedentary range that they have decided that you are. So you have to prove that you cannot transfer those skills. So that's your job. So do the research on the rules surrounding what makes a rule non-transferable, or, what does the SSA have to prove to show it's transferable? And then maybe work from there. That's assuming you don't have a lawyer doing it. Delia says, what if the judge finds you disabled the day before your 50th birthday? Therefore, now they give you credit the day before your 55th birthday, they consider you 55, believe it or not. It's so funny. Me and a judge were talking about it not long ago. We're like, don't know why they do that. But yeah. I think because at midnight of that last day, you're technically finished 55 years. And actually the next day, you're into your 56th year. I'm guessing it's something like that. Isn't that weird? So how do you grab midnight? How do you grab that threshold? So they give you the day. Hey, Cindig's in the house. Hey, Cindig. Thanks for all your videos. I have sent them to a friend who needs them suddenly. Oh, I'm sorry for your friend needing them, but hopefully I can be of help. So thank you. I appreciate it. Richard Pauly's in the house. Hi, Richard. I see a dog. How long does it take to receive CDR review verdict from Social Security? It's almost 90 days. Oh, it's like any other finding of disabled or not disabled. No timeline. I would say I've seen people wait well into a year. I've seen people that never heard back. And it turns out that they were, they passed it, but they didn't know about it. Excuse me.
There's a fundraiser for class 27
All right, can you talk to me about it after? Fundraiser for school. I got it.
I'm gonna go there and then probably go to the.
You're going there now?
No, at like 5 or 6.
All right, well, I'll be out. I'll be out by then. Likes to do the fundraisers at school, which is kind of cool. Recently, they did it's like a staple night dance-a-thon or something. He doesn't know how to dance, but they just wiggle, and it's overnight, so it's like I think it's like 8. Is it 8 p.m. to 8 a.m. or something like that? He said one of his friends went in the bathroom and slept on the toilet. I think he stayed up, but then he went back to his friends who lived close by. Because you're not allowed to drive after you stayed up all night, which I think is smart of the school, obviously. So he had parked the truck at his friend's house. The mom drove them over to the thing, and they had to raise money. We all gave him some cash, and then they went back to her house, and he slept there for a few hours, and then came home. Fun. It's all fun. Teenage years, right? Kathy Clayton said 62 denied, said could do light work. All right, light work would still win you. You didn't pass one of your 2 other prongs, Kathy. 38 years, one company, that doesn't matter. Office work, okay, so you had sedentary work, having computer phone. How does transferable skills work? Spinal stenosis. So their skills are what you learned on the job that you did in the 5 years, that are relevant, the most recent 5 years, usually. So you had, they might have said, they either said you could still do, since you could do light work, you could do an office job. It's not heavy work. And you didn't bump it out any other way. So even if they found you sedentary, limited, even more limited to sedentary, you still would have lost because you had transferable skills. You either could do your past work. I mean, Kathy, I assume you have a lawyer working with you. You're going to have to really think around out of the box. If you can do a sit down job, why aren't you doing your old job? That's what they're saying. You could do your old job. I don't think that they're even talking about you could see in your denial. Was this an ALJ? No, this was initial or recon, right? If you could get your DDE, that would be good. If you have a lawyer, he can get it. CTS, I assume you mean carpal tunnel syndrome. That can definitely affect the typing computer, blah, 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 if that's what your work in the last 5 years entailed. So the typing skills would be transferable, but maybe not. You can't physically do them. Did you robustly work up bad neck, carpal tunnel syndrome affecting everything with my fingers? And did you get EMGs? Did you do all that stuff? The ulnar, I mean, you probably have difficulty with all this. I would think those things would be very relevant to office work. But for whatever reason, I don't know if they weren't worked up enough or the SSA was just doing the checkbox thing. And, it's almost like you have to meet a listing, which you're not going to with those things. So you have to do that threading of the needle and building the evidence that is going to help that needle get where it needs to go. You have to give it the barriers, if you will, the guardrails to steer it along. Your attorney should know how to do that, I'm sure. He can't do it for you, but he can tell you what you need to do. And then if your medical evidence actually says what it needs to say, that's important too. The objective evidence, all those diagnostics you've been getting, right, Kathy? I'm sorry you got denied. Was that recently? Elsay says, yes, you got it right. Letter under penalty of perjury with receipts that I repaid loans. Yeah, well, under penalty of perjury, not just you, but the person that you paid back. I hope you paid him with a check and put it in the memo, paying back loan of whatever, right? So Elliot says, well, guys, I'm on my way to begin the 2,500 half mile walk to town and to Dar Central, Dar General. So I'll see you all later. Joy, don't forget to email me later. I won't. We'll talk soon, Elliot. Have fun with the walk. Michelle says, thank you. You're welcome, Michelle. Kathy Clayton says, the CE doctor noted can't sit, stand, lift no more than 10 pounds. Oh, all right. So that's still, well, he didn't say you can't sit at all. So that can't be a direct quote, can it? Can't sit and can't stand. That means that you're bedridden, right? If you can't sit and you can't stand at all, you're bedridden 24/7. So exact words matter. If he says can't sit more than X amount, can't lift more than X amount, which I think you said was 10 pounds, can't stand longer than so-and-so, that's what you got to look at. And then they found that you could do light work. So somehow they felt that you could, and by the way, even with the sedentary 10 pounds, even if they believe that, you'd still probably be found to be able to do the office work, transfer office work skills, or do it in that same office. No, I don't think that was a duplicate. Well, you maybe, but I think you added a little bit to it, so that's okay. User says, you are a real gem. What? Thank you. Thank you for the form and information. You bet. Don't be a stranger. It is 3 o'clock. We are going to cut out of here soon. I'm just going to try to get to whatever is left with questions. User says, all right, I just got to tout it here. So many people struggle with this type of information and getting straight answers that give you so easily, that you give so easily. Oh, thanks. That's awesome. Yeah, you know, I just eat it, breathe it, and sleep it, and I've been doing it for so long. It's really easy for me. It's just a matter of doing it for so long, I think. Just a girl says, thank you. I do not know who to call about the Medicaid. What attorney? I don't know. Look up Medicaid attorneys. Look under AVO, or look under maybe your state bar association would have some names. Remember, Medicaid is local, so that's not going to be something entirely federal. Are you talking about getting it, or? I do have 1-hour sessions. It's not cheap though. But if you go to joydisability.com and look in the upper right, that's the link for learning more about the consultation times, 1 hour. And then if you do it, it'll go to Liz and she'll schedule it and all that business. So all good. Okay. It isn't cheap though, because most of my work is really doing client work. And then I put in the 2 hours here. So unfortunately, everything else is going to have to, because it takes me away from that. It's got to be not so pro bono. I do pro bonos, but those are selective and waiting lists. So Sybil says August 2026 will be 1 year. I have other things, just too many to remember. Cognitive issues. We'll make sure that they're all in there being, worked up. So maybe start making a list every time you remember one, you add it to the list, and make sure you have a specialist for all of them. User says, my town is full of thousands of people that need to know about you. Oh, well, put out the word. It's all good. The more the merrier, particularly coming here. This channel is how we get to do a lot of those pro bono things, guys. As you know, as well as the 1% and 5%, not all of whom are pro bono, of course. Civil Chick says, kids don't call, they text. Yeah, right? That's true. I think my kids will call if I don't answer a text. ALJ says, I'm sorry, ENS says, can an ALJ use a previous ALJ decision against you? Not per se, but sometimes it's used. I've seen it in files, and that's why I know that. Like, I'll be like, why is it in the SSA file for this case? And I think it's because they need to find out what evidence that guy had that was deemed not fully disabling, and for what reason. A, that is carved in stone from the date of his decision and before. And I also feel like if nothing has changed, you're getting all the same stuff and nothing seems worse, they don't want to refute what he said about that if it's not unreasonable. So like if you have the exact same symptoms and limitations then as you're alleging now, no different treatment that shows anything different, then the answer should probably be the same. Unless you've changed age category or something where the law changes on you. Oh, Civil Chick says, isn't there a number on your Medicaid card? I think she's talking to just a girl. She's just a girl. Just a girl. Sybil says that if you have a Medicaid card, she thinks the number might be on the back of it. You can call and ask Medicaid, I guess. All right, good point, Sybil. Okay. Richard, I'm not really sure what you mean by this. I can work if my unemployment department told me I can't by a judge. First of all, your unemployment department is not your master. If you're collecting unemployment and you go back to work, obviously you got to tell them that you're no longer eligible for unemployment. So don't mix up things. You know, nobody can tell you can't work except maybe a court order that says you are forbidden to work. That's usually happens to people when they are not here legally in the country. They don't have, you know, social security number. They're not a permanent resident, and they don't otherwise have a visa to work. Anyone else can work. Even if their primary care says, I don't think you should work. He's not your boss either. You are an adult. You make the decision. I don't know what Sybil's talking about, but she says, it's okay. Karma is fair. Yeah, that's supposed to be what karma is, right? Poetic justice. Sybil's being parental. Don't smoke, peeps. Yeah, I agree. Just a girl. She's just a girl. If you get medical rides, they sometimes overspray fragrances to cover their smells of smoke. Ah. Huh. Okay. All right. Mike Page says, I'm late to the game. Good afternoon, Attorney Joy. You too, Mike. Yeah, and I'm a little slow here. This is like 25 minutes ago. User says phantom odors. Yeah, I wouldn't be surprised. Okay. Oh, TY226 is in the house. Hi, TY. I'm going to call you Ty, okay? Unless you tell me otherwise. 41-year-old with panic disorder, agoraphobia, and depression, worked retail and been out of work for a year. Wow. Yeah. You're in a really, got a big mountain ahead of you to prove that you can't do any job versus are uncomfortable doing any other job. It's got to be really where you can't. Those things can do that. I assume that you have it bad enough where you probably sought like hospitalization, maybe. Agoraphobia. Sometimes people do like really astute, even if it's like partial hospitalization outpatient, because agoraphobia means you don't leave your house unless you have it mild, in which case they're going to say then get out and work. But I mean, true agoraphobia, if it's full-fledged and not just starting or, you know, momentarily, you know, that's when you're not leaving your house. You're not going out the door. That's crippling. I haven't seen a lot of those. I have had some. And you're young. That's going to make it a lot harder because, well, you know why. It's harder. You have to prove that despite those mental impairments, that they are severe enough that you can't do a job that doesn't involve the public. You can't do the tasks involved in a job that also doesn't involve their job that don't involve coworkers. The one thing that there is no such job as is the one that doesn't require occasional interaction with a supervisor. They say every job requires some level of interaction with a supervisor. So, you know, if there was some proof that actually you would go into full-blown panic attack. And again, what is the severity of panic attack? Every third time your boss asks you a question. I mean, so it really depends. And the proof has to be very vigorous. Like if you're seeing a counselor once a month, that's very de minimis for someone who says they can't work and they're only 41 because of these things. So it would be like, I think you if it's severe, you'd be going to multi times a week therapies. You would not be going to the grocery store, like you're not able to. I don't know what the depression does for you. That's, most people have I'd say most people, but it seems like half the population has some level of depression. Or they're confusing it with life's not exciting, which I think people do that too. But if it's bad enough where you renders you in bed and you don't get out, you don't eat, you don't shower, you're really not living like human for a few days at a time while the severity's in there, and then it kind of floats away a little bit and you can get up. I don't know your situation, but it is the only way to prove these things is through really rigorous treatment, whether that's hospitalizations. If they're so disabling that you can't leave your home, you're basically, I would be in a hospital if that happened to me. I would, trying to get better. But short of that, next best thing is, well, you would think it would be outpatient partial hospitalization where you're there like 5 days a week. And they're working you through group and all these things. Plus, you need your own psychiatrist. You want your individual and you want your personal therapist, not just group, multiple times a week, too. I mean, you have to really, really, there's a lot to prove, TY. And they're not going to take the word of just, the diagnoses are definitely not enough. It's got to be shown. It's like it's a huge walk. So I hope you can do that, because if it's the case where you literally can't get out and do that, and by the way, they could easily say, by the way, you can't do retail work. I would anticipate them finding that. Just even on garden variety therapy records every week or two, you go, you talk to your therapist, telehealth. I could see them saying, yeah, you can't do his prior work because retail is dealing with the public. But you have 12,000 other occupations to prove that you can't do. So how about the ones that don't have the public? How about the ones that don't have coworkers? How do you prove those? That's the difficulty. So you got a lot to navigate there. Oh, Charlene's in the house. She says, Tasha, she says, love your sweet bird. He dances. Was he dancing back there? I didn't see him. Jeremy says, so when there is a federal remand, do you find that the same ALJ generally changes things the second time? Or what does the second? Well, usually it's the same ALJ, but you might be getting a different one, right? Because you're claiming that he was, I don't know. I thought you said maybe you're going to get a different one. Yeah, they're, all hearings run similarly. So they're all going to follow the same general structure. But I would say a different ALJ is going to be focusing on different things. But he's also going to be looking at probably if you have a different ALJ, probably he's going to look at the AC order and see what the old ALJ failed. And he's going to make sure, for sure, that those things are not missed when he's doing his process of filling all the requirements. And that he does them sufficiently, because the guy might have touched on certain things before, but he didn't do them sufficiently if you get a remand. So, I think then you're asking, when you say change things, you're asking about, does he change the outcome? I believe every remand I've had back to the same judge has reversed for me. Not always the original dates, but oftentimes. Sometimes they've reversed but said, but it's going to be this later date when the evidence got stronger. And I'm always like, we'll take it. And I recommend that usually for my client, because you need to, clients suffering through another 3 years of another appeal to have a little bit extra back benefits that likely won't happen anyway. Most people don't want to do that. And I don't blame them at all. Take the bird in the hand. Under a situation like this, when you've already done a federal remand and the person awards you just says it's a little later date. That's what I think. Because you're still going to have a lot of back benefits, because all that remanding is taking time, right? So I do find them to be very amenable to reversing themselves. I've had some that said, I don't even know how this went out this way. I'm so sorry. Because, remember, they don't write the decision. So I almost wondered with one, like, did she actually say that in her notes that this was a denial, or did someone misread something? Or I had that impression at least once, because I just never. And then when we went back to the same judge was, so I don't know. But I've always found them to go pretty well. I know I'm probably due for one not to. And I don't know if a different ALJ would be better or worse, because I've always gone back, I think, to the same ALJ, and they've always done right by us the second time around. So I don't know. I do know that I try to write respectful appeal briefs. You know, I don't get personal with the judge. I just say what the decision, you know, what it objectively under the law failed to do. And that's, you know, something that is probably hard. It was probably hard for me in the beginning to do that because you get very offended when you do it. And I can imagine a claimant being particularly offended. But I think that's the best avenue to take is, you know, keep it very professional, not like anything personal. In fact, sometimes I won't say the ALJ didn't do this. I'll say the ALJ decision fails to do this. So, because remember, he didn't write the decision. Somebody else wrote the decision. But he decided what the result was going to be. And usually there's a couple notes about, you know, pinpointing the major things. And then I'm assuming the decision writers find more things that support that. But the big majors, you know, I don't know if that's how they do it, but that just seems like to me some way that it might be done. Where are you, Tosh? She's just jonesing back there. She ate bakery white Tuscan white toast with peanut butter. I felt like she was really hungry. Like I feel like she doesn't eat all her seeds, and then she went to town. Peanut butter. She loves peanut butter. She likes to, in fact, she'll often eat the peanut butter off it and then toss the other part. So maybe she needs fat and calories, and it's sweet. So Jemmy says, I have a new ALJ but interested in why in the world they send the same exact denial ALJ to let them cause people in. Well, like I said, the same ALJs have always done right by us. And the point is, they point out what the ALJ missed, what legal step. So the ALJ can now do it the proper way. It's not really an attack on their character. It's they made a mistake by missing a step or doing it properly under the rules objectively, and they can go back and do them. So that is why. And like I said, I've never seen them cost another 3 years. They just awarded. So I know that's not always the case. I have a lot of colleagues that, you know, remands didn't work out for. And I believe that's just pure luck, you know. Yeah, I avoid trying to tick them off too, but it's just where the ball bounces, you know. Because a lot of the cases, you know, from an evidence point of view, are close. So it can't really slam someone for being like, it seems this way to me, whereas another reason why might say it seems this way to me. David Carlin is in the house. Hi, David. I don't know that we met. He says, I received my SSDI at age 58. Okay. Is it okay? Is it regularly see my doctor every 4 months? And I think probably that's good. Now, did you have specialists before that you're now blowing off? You're talking about only one doctor. You probably had more for your case, right? So are you saying each of your doctors, like, rotate them? Like, I see my PCP this month, and then within a few months, I see my my orthopedist, or it depends on your situation. But I think you can definitely, it's not going to be the same as when you're trying to prove it, which is usually when the disability is young and you're trying to get cured and you haven't gotten to that kind of like, all right, now we're at a new norm stage and we're trying to maintain what we have, and maybe it improves, you know, but probably just maintain. Earlier you were trying to get answers, get improvement, you know what I mean? PT, injections, whatever. And there might still be injections if it was orthopedic. But if you do it reasonably enough, and I obviously can't speak to your case, but 4 months is not necessarily horrible. But if you are claiming severe pain, you would think you would be doing things that address it still. I don't know. It really depends on your particular impairments, I suppose. But 4 months is not the worst, you know, because remember, they look back at the past year when they do it. So you would have 3 visits. And usually in the short form, they ask for the last 3 visits and when they were. Pardon me, guys. My mouse isn't behaving. Ines, you are so welcome. Hey, Tony P's in the house. Always late to the game, aren't you, Tony? Hi, Stephanie. I was going through my award letter and it just says I was found disabled under their terms. Yeah, the award letter means nothing because you were found disabled on initial or recon. You didn't get an ALJ decision, which would be very robust. What does their terms mean? It means that the definition of disabled, I'm not going to read it to you. You can go look it up. Also, they say I should have a CDR in 3 years in the handbook. Okay. So you're considered to, it's likely that you will improve with treatment. So I would say you just kind of always want to be diligent with the doctors, the same kind of specialists or doctors you saw, plus your PCP. And even if you don't go quite as much, because you're like in the, like I said, the kind of this is the new norm, and that isn't going to cure me. And I've gotten, they built you up enough to where this is now the new norm. You want to show that that still is. And so you want to keep up with medical treatment to an extent that's reasonable, which I can't define what that is for any particular person without really knowing their case inside and out. But if you were seeing orthopedics, I would keep an orthopedist. If you were seeing neurology, I would keep a neurologist. They might want to see you only every year, then maybe try to do them staggered. Try to see your PCP, depending on your age. Nowadays, they want you to see every 6 months anyway, and I'm pretty healthy, and they want to, that's what they want with me. So, and always make sure you complain going forward. Don't stop complaining just because you won your case. Talk about whatever the pains are. I forget what your impairments were if you ever told me, but if it's back pain, talk about the days, that you have to like, every several days I gotta just, I just have to be on the couch all day, or because I did something to it. Well, I don't even know what, because I'm being so mild and gentle all the time, but so something just happens, doc. I don't know why, but I'm getting through, blah, blah, blah. But don't ever say I'm doing fabulous. Don't ever say, like, the commonplace, polite things that we say that are meaningless, but just like cheerful. Don't do it at your doctor's. Just don't do it. I'm great. How are you? That's always our standard. I always say that. Don't do it at your doctor's, because they will put it down. He says he's doing great. Not good. Delvin says, any chance he'll be Jonathan's guest soon on the... Oh, God, I haven't even talked to him in several weeks. I do see him in network, though. But that's where we're all kind of silenced and just... we can take our turns and talk, but... we still attend our group. We got a group. Yeah, I haven't talked to him lately, so... I don't know. You could reach out to him and... ask him. Whenever he emails me, I just do it. There's been a few times maybe when I couldn't, when he wanted, but usually I can. And I love it when he comes on mine too, right? I'm still going to my doctors and also for new stuff coming up as well. This is Tony P. Good. That's key. All right. I should have read that before. I didn't know you had another one. Before I went off on my bandwagon there, Tony. Tennis Boy's in the house. Hi, Tennis Boy. I don't think we've met. It says SSI recipient can travel abroad for 30 days. Is it 29 days or 30 days? Just be sure you can do it for 30 days, or that 30 days it now knocks you off. Just make sure. What if you are informing SS you'll be abroad for 39 days? You'll lose your benefits, at least for till you get back. Then you can restart them, and you're probably going to lose a couple months, right? I don't know if you'll lose both months, like the first 30 and then the 30 and then the 9, or just the one where it goes into the second month. I'd like to think just the latter, but I do not know. It's something you could easily look up, though, I'm sure. Civil Chick says, half mile, I wish... Oh, you're probably talking to Elliot, right? Walking a half mile. Jennifer Murphy's in the house. Hi, Jennifer. I've got narcolepsy and other problems, but but narcolepsy is the main thing. The paperwork is not made for a person with narcolepsy, I think you're saying. What paperwork? It sure is. I've had narcolepsy, people. I mean, yeah, a lot of things aren't going to apply to you, but plenty will, and that's what the point is. Your big thing is all that really astute medical evidence of the severity of the narcolepsy. And that's not that easy, because you fall asleep at home a lot, right? But a lot of sleep tests, redo them, where they see. Michael Reed says, so I have a question. I had a hearing, but I overslept and missed it. Oh my gosh, Michael. Spank your fanny. The hearing was only 2 minutes long. That's because you weren't there. And the ALJ asked was to clarify my past job. I told my lawyers to submit an OTR. Okay. Your lawyers aren't going to submit an OTR unless they think you should have one. And by the way, that has to be done before the 5-day rule that you missed, because Michael. I mean, the judge will already award you if your medical records are clear. So you don't have to worry about the fact that you missed the hearing if your medical records are super clear. The problem is they're probably not super clear, because then the judge would have ordered you. There's probably a credibility issue. The judge would have awarded you without having to go to hearing, because they can do that on their own. You don't have to ask for it. OTR. You don't have to ask for an OTR. They look and review before the hearing, because they like to get people out the door sooner. You know. Michael, you're killing me, kid. Do I think it's a good sign or a bad sign that you overslept? Not a good sign. I mean, that's not a good thing. You didn't even get to provide testimony. You didn't get to clarify things. You didn't get to show him. So you missed that. That's I don't know. I'm sorry that happened to you. But you should have had 10 alarms. You know, Mike's son misses a school bus because, well, now he takes a truck, but he sometimes wakes up too late to get there on time. Not often anymore, because he gets significant repercussions at home. But I'm like, he uses his phone as his alarm. I bought him 2 wind-up ones like we had in the old days. They don't have tech difficulties. And he never used them. And I probably threw them out, which is really annoying. Because sometimes your phone just doesn't go off, whether you press the wrong buttons, which is probably what it is. He probably screwed something up, thought he pressed on, and it wasn't. But I'm like, you know, that's something that's bound to happen, and you have this life-changing event the next day. Get a backup. My goodness, come on. Honestly, it's common sense. And I don't mean to spank you like in front of everybody, but come on. Thank you, Sybil. Sybil says, panic attacks at work. I'm creating and just holding my hand up for coworkers to give me time. Oh, wow. Don't you go to the bathroom or anything? Escape. Michael 40 says, I mean, the ALJ told my lawyers this minute. Oh, okay. I'm sorry I spanked you. But you cannot oversleep. You know you have an oversleeping problem. Maybe stay up too late, whatever. You don't get good sleep. You have insomnia. There could be medical reasons for it. It doesn't matter. Now you know. Have the wind-ups. The ones that go really loud in your face. Have a friend come banging on your door and come in. Give them a kiss. You have to do something if you have family members. And that was a huge thing. So I'm guessing that your lawyers don't do a pre-hearing brief, which is the same as an OTR. I do them on all my cases. I just don't ask for OTR, except when it's OTR worthy. And I kind of know the difference. Because otherwise he would just do an OTR. Yeah, you have to do it. I mean, the lawyer doesn't have to submit it, but I think the judge is saying, send me a brief, because they probably didn't do a brief. And a brief is what takes the most time preparing for hearing. Absolutely the most time. For the lawyer, anyway. So, I don't know about that. Will they do the brief for you, or will they not? Will they just say, dear judge, please look at the medical records and award my guy? He's disabled. All right. I think we're almost at the end here, guys. Michael says, I even have a shock watch, and that doesn't even work. Yeah, get out of the electronics. Stop relying on the electronics. Sometimes you just need some good mechanical clocks. No, they tell me they couldn't request an OTR because she wanted a hearing because of okay. All right. I'm talking about a pre-hearing. A pre-hearing brief is where you're not saying award my client without a hearing. And it's true, if they want vocational testimony, they're going to have a hearing. And a pre-hearing brief is where you're presenting, I mean, minor, massive time. Massive time. if for no other reason, it gets everything so embedded in my brain. It's crazy. I mean, I probably spend more time than any other lawyer I know, but that's because it's like, it does that for me. It also gives the judge insight to what our position is. So it might be something they didn't see. It points out the strongest arguments when they might be focusing on that. I mean, I'm just saying, because remember, they've got way more cases than I do. And no, not, way more cases than I do. And each one is, none of them are their client. So they're not devoting, 50 hours to a client. They're not. So, or whatever it is. So I figure, why not? And some judges don't read them, I'm sure. Some judges express gratitude, and if nothing else, I think the ones that don't read them, at least they know that they don't have a reason to dislike the lawyer for being slacky. They know the lawyer put in a lot of time. That's not going to make the client win, the fact that the lawyer put in a lot of time. But it's certainly, I don't want to be the reason why they're like, I don't know. I just think, always both people need to show that they're true blue. So when would somebody not do a legal brief? Because they don't think they have a winning case. They got nothing to show. I mean, I don't know. I always put it out there. So anyhow, we're almost at the end here. It's just Danny's left and we've gone over time. Oh, wow. We've gone 40 minutes over time. We're almost at 3 hours. Danny says, so Jay, this arm brace has me hot, but in the meantime, we got anything coming. That last date shirt thing is June 26th. Yeah, because you haven't worked. So, try to get whatever else in you can, because that's going to be, what that means is if your DLI is in 1 month, end of June, it would be June 30th. Only your treatment going up to June 30th is going to be able to prove that you're disabled while you're still insured. Assuming you're even an SSD case and not just an SSI case. Right? So take that to heat, guys. Your DLI is really important if that's what you're dealing with. I'm not sure, Danny, about. I'll have to look. Anyway, that DLIs, your medical evidence, get all your MRI. You got to make sure everything's in. The MRI takes place before your DLI ends. That updated MRI, or that, X-rays, which are kind of weak, EMGs, whatever's going on. All right, get that PT in. Get a bunch of it at least started. It might continue after, but get it started. If you're getting injections, pain injections, don't wait till after your DLI. Because if that's the one thing that's going to tip it over the edge, now it wasn't available to tip over the edge before your DLI, and you can't win. All right, we got a late arriver to the table, and I am cutting out after this one, I promise. Nobody else, okay? So I am losing my voice. Dark Troubled Soul. I'm sorry you are a dark troubled soul, but what can I do for you? Hello, I'm 51 years old and already on disability. I have had a lumbar fusion, did you say laminectomy? And spaces put in between L3 and S1. I am really sorry about that. What's my chance of being forced back into the workplace? There's no chance of you being forced back into the workplace. No one forces anyone to go to work. So you've got that blessing. I think what you probably meant is, what is the chances that I lose on a CDR? If you're continuing to treat robustly for what it presumably is continued back limitations and pain, I think it's probably slim. You'll have your CDRs. If you just had a surgery and it makes you much improved, then maybe you could go and do if they said you could do light work, I don't know. Just keep your evidence ongoing as to the lumbar problems and any other new problems. Keep track of that. Add your new stuff to your, know about them, follow them up. Sometimes we have lumbar problems and they become thoracic or cervical. Sometimes if we have a bad back, it starts becoming, you're 51, the knees sometimes start to go. Every little thing can add to it for a CDR, not just what you had. All right. So don't have a dark troubled soul, okay? And just if you stick with if you don't improve and you continue to go to the specialists and continue to treat with your PCP, complain about, status, and I think you're going to be, CDRs are really not that big of a deal unless you have improved, which you show by not going to your doctors, right? Or you have the surgery and when they do follow-ups, you say, oh my God, I'm so much better. Are you really so much better? Um, you know, be careful how well you describe it. I mean, sometimes it changes the fact that you can sleep comfortably, but you still can't walk around more than 40 minutes at a time. And people will say, because sleeping now when you lie down, you're comfortable. That really doesn't change whether you can work or not at all. Because from a physical point, you still can't, if you can't walk, that much. So just be careful that you don't say you're wonderfully well. It might be interpreted as your whole day. You're so much better. You can do stuff when you can. I don't know how long you've been on disability, but whenever you're, there's going to become a time when you don't have 5 years you don't have any work in the last 5 years, or no SGA work, and so that might be a difference too, depending on what your past work was. Now you won't have any, and that makes it a more comfortable CDR for you too, because they can't argue you can do past relevant work. You improved enough to do your old job, if it was sedentary or something. So anyway, just to a reasonable degree, stick with the follow-ups, and I think you'll be fine. And don't be dark and troubled. Look at the positives. I'm hoping you have some. Hopefully the surgeries make you better off than you were, even though not improved enough to work, right? Hopefully your pain is lowered. And I'm not saying we have to all be Superman and, going downhill skiing and stuff. I mean, the things we used to do when we were young, I miss them too. But just being out of pain when we're doing our regular, normal, gentle, life activities is a blessing, I think, for people who otherwise have chronic pain. So I hope you're at that point, or you get to that point. Dark, all right? So keep a good attitude. All right, and you're welcome. And Dimple, good to see you. I will talk to you soon. Bye, guys. Have a great week. I hope to see you. Check in on our 12 o'clocks. A lot of them are right now segments from prior Q&As. But there will be some other ones in there coming up. Just it's been a little busy. But anyway, if you do watch them, that really helps the channel, and then it really helps us take on more of the pro bonos and the 1 in 5%ers. So the better the channel does, the more we can do that, because it pays for them. It pays for the people that work on them, excluding myself, of course. All right. I will talk to you guys later. Have a great week. I hope to see you next Wednesday, 1 p.m. Eastern Standard Time. And please do visit the dailies. I'll talk to you later. Bye-bye.